Okay, so good morning, everybody. It's such an alloyed pleasure to welcome all of you and introduce this conference, also on behalf of Matthew Burney, who is the leader of the Jean Monnet Network, EU-China Legal and Judicial Cooperation, which hosts the conference. The new Chinese Civil Code is a long-awaited achievement. For decades, China has been chasing the project, or we could say the dream, of a civil code. Being committed since the early 20th century in a huge work of reproduction of European legal models as the only way to enter legal modernity, China made of the codification of private law the paradigmatic element of this process. No modernization without codification, I would say. And now we finally have the code. And this code, in the words of one of its fathers, Professor Wang Liming, it's an epoch-making law, not only for China, but for the entire civil law world. Here are Wang Liming words. If the advent of the French Civil Code in the early 19th century and the German Civil Code in the early 20th century were significant achievements in the history of development of civil law, then the promulgation of the Chinese Civil Code in 21st century will surely be meaningful and momentous chapter in the history of civil law. In order to give our contribution to the knowledge of this momentous chapter, Matthew Burney and I invited several distinguished guests who we would like to warmly thank for having accepted our invitation. The Chinese Civil Code is at the center of a regulatory process crossed by increasingly intense circulation of national, supranational, hard, and soft law models. In this context, the issue of local identity and cultural differentiations in the relations with the non-Chinese models have been emerging, raised by both Chinese leadership and by scholars. And the latter, Chinese scholars, have been increasingly coping with the problem of self-definition of their own legal culture within the legal world. And this definition is being framing not only in the practice of transplants and borrowings of legal models, but also in the complex game of interaction between global and local dimensions, between the set of private law rules shaped within the framework of the law of the market, the jus mercatorum, and the new definitional processes for a state's sovereignty, especially in the digital field. Digital sovereignty is the last frontier of the law process in China, and not only in China. And this code has something to say also in this direction. Today, we open a reflection that we hope can help us to elaborate interpretation and moreover to perceive the experience of the Chinese Civil Code. We talk about the history of the codification process, the practices of imitation, selection, and hybridization of legal models which affected the code. We talk about specificities linked to the historical time in which the code is born. And to drive this reflection, we have civil law scholars, international law scholars, comparative law scholars. We have law professors and practitioners who live the daily life experience of the civil code. And to start the exploration, the guiding contribution of legal history is our precious torch. Now, Professor Thomas Duve, who taught us the lesson of entanglements in legal history, gives the keynote speech opening this conference. Speaking about codification, some remarks from the perspective of global legal histories. This is the title of Professor Duve's speech, and I'm pleased to give him the floor. Thank you, Professor Duve.
Yeah, thanks a lot, Marina, dear colleagues. It's a great honor, really, for me to participate in this conference, and even more so, as I already said, I'm not an expert in Chinese law or Chinese legal history. I can only speak to you as a legal historian who's trying to understand the historical processes of exchange of legal knowledge in times of globalization, beginning with the massive European expansion since 16th century, according to the Christian calendar. As part of this research at the Max Planck Institute, we are developing methods and perspectives that, as we hope, can help us to better understand the current globalization and localization. We sometimes speak of glocalization of law and legal scholarship. So if we go to the next slide, please. Today, I will give only a short introduction and add some remarks on the history of globalization of law and legal scholarship in 19th and 20th century. In the third part, I will give an overview about how a complex process like the Chinese civil law codification, intimately linked with transnational exchange of knowledge, has traditionally been analyzed. And in the fourth section, I will focus on why I believe that it can be helpful to understand these phenomena as a process of production of normative knowledge through cultural translation. Next slide. The new Chinese civil code already has a history. Usually it's linked to the project of the civil code of the Great Qing dynasty from 1911. It was at this early stage that the German model of the BGB, of enduring impact on the history of Chinese civil law reforms, was adopted. As our convener, Marina Timoteo, pointed out, the further development was marked by a complex game of continuity and discontinuity. It led to the promulgation of a series of sectorial civil laws, which were taken up by the Chinese legislator in what she calls a code compilation approach. The choice to stay in continuity with the previous normative path, she points out, has gone hand in hand with a stronger emphasis on local contexts. The affirmation of the national goal of creating a socialism with Chinese characteristics, but also Article 8, providing that civil law subjects and civil activities must not violate laws and must not act against public order and good customs, and Article 10, referring to customs as a source of law, open the civil code for adaptations. No doubt, these articles can be read as a consequence of the new strategy emphasizing the specificity of the Chinese legal reforms in the framework of the theory of rule of law with Chinese characteristics. That is one of the core issues of the 2014 CPC resolution. Most recently, the Chinese Communist Party also released its plan on building the rule of law in China for the years 2020 to 2025, which might even strengthen this tendency. Adaptations to the Chinese needs, however, is not only a plan for the future. It has happened continuously. In some cases, as a consequence of translation, a new Chinese vocabulary has emerged during the last century. And there are, for example, intense scholarly debates, as you know much better than I, about the usefulness and adaptability of foreign legal dogmatics. Research has also shown unexpected trajectories of conceptual migration. Moreover, as Professor Timoteo highlighted, some catch-all principles, after having entered the Chinese legal system as part of a legal transplant packaging, have been living a life of their own within the context of local legal mentality and local legal processes. The hidden dimension of latent ideas in the interpreter's legal mentalities that impinge on the operative aspects of the legal rules might be, as she rightly points out, the really transformative forces. If this was true in the past decades, it might be even more so in the future, with the interpretation of these transplants following a different mindset, not to search in the first place for a convergence with the Western models, but for a convergence with Chinese normative reality and the Chinese legal tradition. So no originalism, if one wants to say it like that. From a legal historical point of view, this complexity, sometimes described as legal hybridity, is not so surprising. On the contrary, it is nearly the standard case of legal history, and this leads me to the second part, and the next slide, please. That hybridity is the rule not the exception, is true for early periods, but also for the often so-called legal modernity. Because even if 19th and 20th century are usually considered to be the epitome of legal nationalism, they were at the same time a period of intense circulation of legal ideas, of people and books, of models of codes and constitutions. They were a period of globalization of law and legal thought under the conditions of Western imperialism. We can see this on a global scale, for example, in Latin America, where independence from Spain and Portugal did by no means free from colonial power, but on the contrary, led these nations to become embedded into a new structure of the informal empires of capital. It also becomes clear from the long-lasting impact colonialism had on the later evolution of Chinese law since the Opium Wars, as Li Chen has shown. Thus, and from a global historic perspective, the codification period can be seen not only as a period of nationalization of law, but also of denationalization due to the intense exchange of knowledge. This was happening not least because of the massive effort to collect and translate models of codifications and constitutions that circulated all over the world. In China, from 1895 to the revolution in 1911, especially after 1901, the Qing government established the Bureau for Legal Reform and the Bureau for Constitutional Compilation. In the following years, and not only in China, collections of translations of foreign law were published. 1907, for example, the 32-volume publication with translations of Western constitutions. The English title would be The Essence of European and American Politics. Or only 2 years later in Germany, a collection of constitutions, Paul Posners Staatsverfassungen des Erdballs. As Li Fupeng, a Chinese legal historian teaching at CUPL, has shown, the latter two are also a clear expression of the mindset of their authors. In the German case, the collections were organized according to concepts taken from German colonial law. In the Chinese case, they responded to Confucian thinking. Li Fupeng has also shown that the reception of foreign law cannot be reconstructed by a model that only looks at two countries and not even only on the axis West or Europe, Asia, but has to take into considerations many countries, and not least the inner Asian exchanges, especially the translations from German to Japanese and to Chinese. The next slide, please. All translations were necessarily an attempt to understand the German text in these images you see there, the German Staatsrechtslehre, and to assimilate them with one's own understanding. In these processes, we can not only see the importance of the knowledge infrastructure that was built up, but also identify other factors that impacted the translation, and thus the production of the normative knowledge for the new codes, like language channels that linked particular language with particular fields of law. Next slide, please. A closer look at these processes also reveals that even under constellations of imperialism, and obviously with huge differences in each and every specific case, the reception of foreign laws was not always and exclusively an imposition. It was also a selection, an adaptation where willingly or unwillingly, the local conditions had transformative effects. Like in other historical settings, the shock and response historiography that reduces 19th century law reforms in Japan or China to a passive reaction to imperialist pressure does not do justice to the complexity of the responses that were triggered by Western legal imperialism. So how do we cope with such complexity analytically? This leads to the third part. We all know that these processes are often referred to as legal transplants: transfer, circulation of ideas, reception, etc. Sometimes these are simple names, but some of these concepts have been, and in fact still are, heavily debated, not least in comparative law. Personally, I have some problems with all of them, not least because they all suffer from a certain essentialist drift. The transplant is a transplant of something, just as the reception or circulation of something. This insinuates somehow that there is something unchanged. If not, it would not be the same. In addition, these notions do, in some cases, stem from analytical traditions deeply informed by Western modernization theory. This is why I think it's an interesting topic to speak about, no codification without modernization, because we have these ideas about multiple modernities, etc., which I think we have to reflect a bit upon. They thus induce us to fall back into the Eurocentric narrative of legal modernization as a process spreading out a Western model and looking at not yet or deficient receptions. These notions structurally lead us, third, to underestimate the creativity of the so-called receivers and the force of the local place, so important as we have seen. And finally, they do not connect us with a field of professional expertise in analyzing processes of cultural exchange, and concepts should precisely make us see more, not less. These are some of the reasons for why, from a legal historical point of view, we here in Frankfurt at least, or I would suggest to analyze these situations as a process of production of normative knowledge through cultural translation. This leads me to the fourth part and the next slide. What does this perspective, by the way, not least inspired by H. Patrick Glenn's work, mean? Let me summarize it briefly. We're speaking of knowledge because the term, and notwithstanding its many variations, is extremely wide and includes discourses, principles, norms, rules, and, very important, practices. Looking, for example, at the making of the Chinese Civil Code, in a longer perspective, it becomes clear that this is necessary because our observations cannot be reduced to statutory law or legal ideas, as is often the case. On the contrary, when asking for the knowledge that was activated in the process of the making of the code, we have to look at the cultural competence, the mindset, the principles, often deeply rooted cultural legal practices that those who were producing the code had in mind, but which are perhaps nowhere written and expressly formulated. Asking for the legal knowledge, by the way, also helps us to overcome the opposition of law in books and law in action, a deeply dysfunctional binary notion. We are, however, speaking not of legal knowledge, but of normative knowledge, because it would be too narrow to reduce our field of observation to those normative spheres that are labeled law and thus understood from a state paradigm and a Western paradigm. China might be a very good case to understand the importance of non-legal norms for the social life and their deep intertwinement with state law, and also their role for law in lawmaking. We are finally looking at these processes, like the codification process in China, as a production of normative knowledge through translation. With this, we are referring to lingual translation, but not only. We are referring in the first place, I would even say, to what has been called cultural translation. Understanding the processes usually labeled as reception, transfer, etc., as cultural translation can draw on a quite well-established research trajectory in the translation studies and in cultural history, and mobilizes its theoretical potential for legal history. The biggest value, however, of the perspective of translation lies in the fact that it virtually forces us to assume not a transformation of something in an essentialist way, but that it puts us into the place of the translator or the producer. We have to take the position of those who select from the huge offer of normative knowledge available, who opt for example, the German model and not the Italian or the French or the common law models. This means to ask for the reasons of this active process of selection, for the guiding mindset, the tools he or she has at hand, the material and immaterial conditions of the translations, and the transformations that occurred in this process. It obliges us to take into consideration virtually all circumstances of the act of cultural translation, like, for example, the power structures and their impact on the selection process, the cultural preferences, or simply the contingencies of each case, like personal ties, encounters, personal interests. Not least, it gives us a place to reconstruct in a very concrete way general assumptions about the nature of law, or, for example, the value of tradition. It has, by the way, another advantage. Since in the production of normative knowledge itself, the entire normative knowledge is activated because the practices of norm production themselves, like learning how to structure a code, belongs to normative knowledge. The production of normative knowledge is a performative practice. In the act of generating normative knowledge, this body of knowledge changes, or more concretely, after having made a civil code, those who have participated in it would not do the same work anymore. They are already different. They have experiences they will activate next time. Next slide, please. Finally, from a legal historic point of view, looking at legal history as a huge process of production of normative knowledge through millions and millions acts of cultural translations has the advantage of a radical change in perspective. We do not longer look at the 19th and 20th century as a process of legal modernization from a Western perspective, where Western law spread out. On the contrary, we are looking at the world as a huge and interconnected process of knowledge creation, without searching for deficient implementations of a model, the not yet, the latecomers, and giving creative transformation a place in our images of the world of law. This is what I want to show a bit with this, the slides, the graph, where you can see that we can perhaps grasp better the networks and not only the centralized, or not even only the decentralized knowledge production. Finally, and with this I'm reaching the conclusion, the perspective is obviously not restricted to the codification process as such. Next slide, please. We all know that the life of the law is much more than the application of the statutes of a code. If we want to understand the significance of the code, we have to know something about its use. This might be especially true in the case of China, with its historical and structural openness for non-legal normative spheres and its political interpretation of the law. So when trying to understand the implementation of the code, its real significance and transformation, one will have to look at legal practice, at the Supreme People's Court or at a local level. The good news is that one can do it using the same method. We can analyze, for example, a court sentence as a production of normative knowledge through an act of cultural translation. This would lead us to ask, how did the individual judge translate the legal knowledge that was available in his or her concrete place and time? What was available? What were the means they had at hand? What was the role of the civil code? Did he or she opt for applying it or not, and why? What resource, normative resource, was activated instead? What were the local conditions that were behind this practice, which is not simply wrong administration of law or not? We do not have to make up an abstract frame of ideas, but we can trace very concrete connections between mindset and action. As Professor Timoteo rightly pointed out, not least the hidden dimension of latent ideas in the interpreter's legal mentalities are of huge importance. This dimension, she goes on, which goes well beyond the official rhetoric of Chinese characteristics, still needs to be studied in depth as a part of the current process of codification of Chinese civil law, a process where, as emerged from this first reading, flow also standards and principles that trigger a chain of references at the end of which there are rules of cultural origin. I could not agree more, and I would be glad if the analytical toolbox of legal history could be of some help for this undertaking. Thanks for your attention.
Matthew?
Very good. Thank you very much, Professor Duve, for this very thought-provoking keynote speech. And I think it very nicely sets the floor and it sets the stage for the rest of this conference. And my suggestion would be, if you don't mind, that we give the audience the opportunity maybe to ask you questions after the first panel. So maybe indeed, if there are any specific questions regarding Professor Duve's presentation, please feel free to raise them after our first panel. So it is now my pleasure to introduce you to our three speakers for this first panel, which will focus on the Chinese Civil Code in context. For that purpose, we'll have three speakers this morning. We'll start with Professor Marina Timoteo, who doesn't need that much introduction. Professor Timoteo is a full professor in comparative private law at the University of Bologna, and she will focus this morning on, I quote, the Chinese style, a civil code for the 21st century. Her presentation will be followed by a presentation by Professor Chen Lei, who holds the chair in Chinese law at Durham Law School in the United Kingdom. But Professor Chen also keeps very strong links with his alma mater, the City University of Hong Kong. And this morning, Professor Chen will speak about, will make a critical assessment of the Chinese Civil Code, looking back and thinking forward. Last but not least, our third speaker today comes from Unidrough. Professor Veneziano, Anna Veneziano, is indeed the Deputy Secretary General of the International Institute for the Unification of Private Law, but she's also connected to the University of Teramo in Italy. And Professor Veneziano will make her presentation this morning on the Unidrough principles as an inspiration for legal drafting and the Chinese Civil Code. So this is, let's say, the menu for this first panel. Before we get started, may I kindly advise the audience and all the participants to raise your questions on the chat. So if you have any questions for Professor Duve or any of our three speakers for the first panel, I would be very grateful if you could raise them on the chat, and I will then be very happy to relay them back to our speakers after their presentations. So without any further ado, Professor Timoteo, the floor is yours. And again, many thanks for having kindly agreed to co-organize this conference with me. Marina, please.
Okay, here I am. Thank you, Matthew. Let me start my speech by thanking all my Chinese students. Some of them are connected with us today. The exchanges of ideas, suggestions, the experience of cultural translations with them, is the precious fuel of my research life. So thank to all of you. My narrative takes its starting point from three sentences coined by scholars who were deeply involved in the process of codification of civil law in China. Three sentences which represent crucial aspects of this process and define some core elements of the Chinese style approach to civil code. And this is the first sentence, 莫这石头过河, crossing the river by feeling the stones. This is a sentence pronounced by Professor Zhang Ping after the approval of the Chinese Civil Code last year. Zhang Ping, born in 1930, belongs to the first generation of law scholars of the People's Republic of China, one of the still alive law professors who has personally experienced all the passages of legal history in the new China. After the revolution and the foundation of People's Republic, was amongst the first scholars who went to Soviet Union to study socialist law. And when he came back in 1956, he joined the faculty of Beijing College of Political Science and Law, now China University of Political Science and Law, where he is emeritus. After the Cultural Revolution, he was amongst the group of scholars called to build the private law setting for the new China of opening up and reforms. And he contributed to the elaboration of 1987 General Principle of Civil Law, 1999 Contract Law, 2007 Property Law. So he described the path toward codification of civil law as an experience of crossing the river by feeling the stones. This sentence recalls at first glance the idea of a progression step by step. And this appears in line with the piecemeal and incremental approach chosen by the Chinese legislator to build and regulate civil law for China of reform and opening up. At the beginning of the 80s, Chinese Journal of Civil Law published an article titled, "What kind of civil law should we enact?" where we read, first of all, we should adhere to the principle that civil law is public law. It is a great civil law that adjusts the economic relations between the public and private, and between privates, rather than a small civil law that only adjusts the economic relations between individual citizens. Civil law is a public law. This was the starting point in the endeavor of crossing the river, an endeavor which, for example, led civil subjects moving from the public law status of citizens to the private law status of natural persons. 1987 General Principle of Civil Law still refers to citizens, but right after the word citizens could mean the expression natural person, deriving from German law, was placed in brackets as an indication of a reforming process in progress. 99 Contract Law only referred to natural person, freeing the expression from brackets and marking the transition from the public law concept of citizens to the private law concept of natural persons. And after the contract law, real right law, tort liability law completed the passage to the new private law. These laws have, with the other laws in the private law field, have been now abrogated and merged into the special parts of civil code. But crossing the river by feeling the stones is also something more than a mere idea of a process step by step. A closer look at the first character of the sentence, more, to feel, can help us to catch the meaning. More is a sound meaning compound where the right part gives the sound more and the left part conveys the meaning and is the semantic clue to the meaning of the word. The idea is touch with hands, feel by hands. Crossing the river, feeling the stones means to explore an unknown territory, that of transition to the market economy, to a new system of private law rules, touching and feeling by hands this experience. The evolution of the land ownership rules is an exemplary subject issue in this regard. Land in China belongs to all Chinese citizens. Private ownership of land is not permitted in China. Only public ownership do exist. Now, how to reconcile this unavoidable rule of a socialist state in transition to market, which need to insert land into the market economy? The solution was found in the system of land use rights, which were made divisible from land ownership, thus making possible for the use rights to be privatized. And this was made through an amendment at Article 10 of the Constitution, where the right to use land may be transferred according to law was written. A crucial distinction between urban and rural land was introduced as far as the market transferability of use rights are concerned. Only urban use rights were made available for market circulation. In the case of rural land, which is under a collective ownership regime, a two-tier land tenure system was first tested in some rural areas and put in place. In this system, ownership rights were retained by the village collective, whereas the use rights were granted to households. However, in order to secure collective farmers' land use rights attached to their collective membership, several restrictions were imposed on the transferability of these use rights, which was limited to small-scale intra-village transfers. This system started to show all its critical factors as the urbanization process led more and more rural residents migrating to cities, leaving vast areas of rural land idle in the countryside. Thus, a new system started to be tested in Hubei, Shandong, Jiangxi, Zhejiang provinces. And it was a tripartite system, 三权分置, that separates the ownership right contract rights and management rights of the land. The latter becoming freely transferable to external parties, including external companies such as agribusiness and tourism companies. This tripartite right system is now regulated in the code. Now, the evolution of land ownership rules, they are reshaping through the introduction of land use rights, where when made divisible from land ownership, the splitting of the contract rights into two separate use rights, which after having been locally tested, entered the civil code, are exceptions to the classic modern civilian concept of the compact form of ownership, which has been imported in China. And they are Chinese exceptions. They have been introduced and progressively reformed, responding to legal, economic, and social needs. They have first been tested, as happens for the most relevant reforms in China, and finally landed into the code. And this was jumping meant by crossing the river, by filling the stones. This approach which marked all the civil law reforms in China and which concern all the books of the Chinese civil code, brings into play the issue of the relations of Chinese law with foreign models. And these issues not only regards problems of connection of new rules with important taxonomies, it also has a connection with process of rethinking relations between Chinese and foreign models. As we all know, China has been experiencing a massive process of legal transplant in the last century as the only way to enter legal modernity. And in this process, civil code always remained a final goal, and a main reference model was and still is the German code. This model, in its classical version, places intellectuals, scholars, in a central position in the legal process. And in China, a strong group of scholars has been cultivating the German model and strongly support it. They proposed a 5-book code, with the first one strictly patterned after the first book of BGB. However, a growing number of scholars started challenging this pattern, this paradigm. And the end of the story has been a code with some but limited influence from BGB. And we arrive at the second sentence of our exploration. 这不能在外国法学这世纪的理论者中跳舞, which means we should definitely not dance in the cage of theories of foreign scholars. This is a sentence by Wang Liming, one of the fathers of the Chinese Civil Code, great supporter of the inclusion of the book on personality rights into the special part section. Born in 1960, he studied in US after the law degree in China, and he introduced in the Chinese legal discourses comparative law approach and the common law perspective. This softened the influence of German law in the Chinese system, where in the code we found some but limited influence from BGB. This influence is in the structure, as the new civil code follows the structure based on general special parts combinations, Zunze, the first book, and Fenze, the following books. Together with the structure, some paradigmatic elements of the German model, first of all, the category of juristic act is maintained. And so it happens for several private law concepts, such as personhood, natural and legal person, legal and juristic act, real rights, property, possession, obligation, civil liability. However, first of all, the organization of special parts of the Chinese Civil Code follow a path different from that of the German Code, not having accepted, for example, the idea of a book on obligation, which has been considered too theoretical, and introducing a new book, which for the first time is part of a civil code, that is the book on personality right. Moreover, many concepts of German derivation have been reworked and contaminated with concepts, taxonomies, and rules which do not have a German origin, especially since the drafting of 1999 contract law, common law models, uniform law models, European Union legal models started influencing Chinese legal process, and borrowing became a selective activity. German model still has a legitimation role based on the prestige of the model, but it is only a part of a bundle of borrowed traits and regional traits, which have been mixed up and even twisted around, producing a different model. So freeing the Chinese law from the cage meant to conceive borrowing foreign legal models as a selective activity, which ends in contamination practices. The Civil Code repeats many of some contamination already experienced in the last few years in private law, and also introduced new contamination. For example, the rule on punitive damages had already been introduced in the tort law, but in the tort law, we find the new rule of the Good Samaritan Immunity Clause of American law, which was inserted in Article 184. And in the rules on collateral, we find the introduction of the purchase money security interest taken from scratch from the Uniform Commercial Code. And this code is the full expression of its time, which is a time marked by hybridization of legal models. And in this process, a growing role has been played by the Chinese characteristic, that are those rules that are a direct expression of the local context. An obvious example is found within the discipline of legal personhood, where the legislator has not followed the taxonomy of the German code, which was proposed by the German law scholars, introducing a new classification, more practically oriented, according to which legal persons are classified in three categories: real person for profit, no profit legal person, and special legal persons. Now, this is our last sentence. From legislation theory to interpretation theory. 从立法论到解释论. The code has been written, and the attention of the scholars is directed towards new points. Being aware that we are in a more complex legal context, which took the place of the oversimplified picture of legal modernity, where legislator, statutory law, and few dominant legal models were the only protagonists of a scene, a growing number of Chinese civil law scholars opened a deep reflection of interpretation with regard to civil code. And here is one of the most important law scholars working for the move from legislation theory to interpretation theory. This is Professor Xie Hongfei from Chinese Academy of Social Science. He's a representative of the middle-aged Chinese civil law scholars. He is born a decade after Wang Liming in 1973, and he's director of Civil Law Research Institute in Chinese Academy of Social Science, that is the stronghold of the German law school. And the discussion has just started in this regard. I would like to make some final remarks on this move from legislation to interpretation theory. I think there are two crucial aspects which have to be outlined. First of all, a need of work with rules, concept, and taxonomies has been emerging. Returning to the subject of property law, how to reconcile a system of variable group of limited rights with the classical concept of a compact and absolute right. If a plurality of ownership situation exists, analysis of property rights requires intellectual instruments able to capture the complexity of legal arrangements and their translations into specific situations. And last but not least, the code, as every civil code, is full of catch-all principles and standards. I personally have been following the diffusion in the Chinese court reasoning in the private law field of the standard of reasonableness, which projects the long shadow of the local mentality into the Chinese civil law. Yes, contemporary civil law is not only made by receptions, contaminations, creations of new taxonomies, progressive elaboration of new solutions for the emerging issues. Interpretation is, as everywhere, the engine of the law in action. And this is the favorite place where cultural roots and latent ideas work. The early reasonableness, which I studied as an hermeneutic key, not only in contemporary law, but also in imperial law, is also a connecting point with uniform law, international law rules. And it will be interesting to follow how this mix of factors, how in this mix of factors, the Chinese way will emerge. And to envisage the Chinese way, let's once again have a last look at the language. Curly, here the reason is in the second character, li. It's a sound meaning compound, and it's made by radical of the jade of the left, that is the ideographic clue to the meaning, and on the right side, the character li, a measure that is a phonetic part. The semantic root of the character li is that of texture, vein of jade, vein of wood, vein of stone. The concept behind this word in its most ancient meaning is that of the pattern in things. Jade is a precious stone that can be worked easily if the engraver is able to follow its natural markings. Li as a verb means to cut things according to their natural grains or divisions. Die, in the wider sense, judging means to look for the veins. Interpreting is to look for the veins, to look and follow natural pattern in things. And this is the Chinese way. Thank you.
Thank you very much indeed, Professor Timoteo, not least for this very interesting presentation, but also for very much sticking to the time. I'm extremely grateful for that indeed. It is now time to move on to our second speaker, Professor Chen Lei from Durham University. Professor Chen, the floor is yours. I don't know if you intend to share slides, but you should have access to the share function.
Yes. Thank you, Matteo, for your very kind invitation. It's a great pleasure for me to be invited to join this conversation. I am struggling to share my slides. This is kind of a new version of Zoom, so I couldn't locate my file. Let me see.
So you have the share function at the bottom of your screen?
Yeah, I tried. Let me do it again. Well, I cannot find it. Never mind. Maybe I advance the sharing options.
So it's a green button.
It's only host. Let me change.
But you are a co-host, so normally you should be able to do it.
Yeah, I confirm that Professor Chen Lei is co-host.
Yeah, thank you. But yeah, anyway, I can just
now
talk.
We can't hear you.
Can you hear me?
Yes, we can.
Yes, we can. Yeah, okay. Sorry. Maybe I can just yeah, no worries. I can just talk.
If you want, just send it to me if you prefer, and I share it for you. It's up to you.
Yeah, I can send you.
Okay, hold on, I send you the my email.
Yeah, sorry for this drama.
No problem.
Maybe I.
The share screen icon, it should be at the bottom. It's a square with an arrow.
Yeah. I do use Zoom, a lot of time, but this time they have, I don't know, they have a new version. They asked me to use the web page version because my version is a bit outdated. I think that's the reason why I couldn't. Sorry about that. So I sent you, maybe I can send you Mathieu.
Yeah, please send me, you can feel free to send me your slides to start, and then I
Yeah.
will upload them online, on screen as soon as I receive them.
Okay, excellent. Let me just. Yeah, I sent already. So let me, to save time, I can just start. So today, I just learned quite a bit from the previous presentations, both from Professor Dewey and Marina. And my presentation mainly focused on the positive side of the story. So turn from the normative analysis to the positivist side, trying to give you a general overview of the Chinese Civil Code. The purpose of my presentation today is threefold. The first, I will provide the reasons for and against the introduction of Chinese Civil Code. And second, I will present some notable rule changes in order to facilitate a critical evaluation of some salient features of the Chinese Civil Code. And third, I will talk about what happens after the enactment of Chinese Civil Code. I have to make two caveats at the beginning. The first is, in the interest of time, the overview will not cover each and every aspect of Chinese Civil Code, which is a piece of mega legislation, covering 1,260 articles. The second caveat is any general statement on the Chinese Civil Code solely concentrating on the paper rules would fail to capture a complex reality without paying regard to the underlying social, economic, and political contingencies and the judicial practice. So there are two salient features I need to introduce at the beginning. The first is China has a civil law tradition. The civil law tradition underpins Chinese private law. When the Chinese Civil Code was drafted, the Chinese lawmakers are making lots of reference to common law and mixed jurisdictions legislative experiences, in addition to the civil law sources. But by and large, Chinese private law will remain congruent with continental civilian law families. Very often, people talk about the Chinese legal system as a socialist legal system. It's true from the ideological perspective. Stripped off this ideological cover, in essence, Chinese law present very salient features of civil law tradition. The second feature is compilation versus codification. I think it's fair to say that technically this round of codification legislation process is a compilation, because the Chinese legislature in the last 20 years has adopted this piecemeal approach by making contract law, property law, tort liability law, and family succession consecutively. So in the end, around sometime last year, they successfully compile all the pre-existing legislation together. So that would affect my analysis on evaluations. So reasons for introduction, there are three major reasons, in my view, for its introduction. First, at the heart of the issue in China is that at this transitional period towards the market economy, how the state users and the right holders use the legislation to ensure a smooth transition from fragmented regulatory rules to a streamlined, uniform, law-oriented legal system, right? That is fits in the law and the development theory, which argues that in order to achieve sustainable economic growth, any legal system need to incorporate property rights and ensure the contract enforcement. So obviously that is a part of the story. The second reason to embrace its introduction is this: the codification of Chinese civil law will facilitate private sectors and foreign investors' mobility by increasing the legal certainty and the predictability. Because in China, there's growing middle classes. They are voicing out the concerns in order to preserve and protect their assets and the properties. And the third reason is it's very technical. The Chinese Civil Code brings about a tangible benefit, making locating rules easier by tidying up all the existing civil law rules in a comprehensive measure. But there are, at the same time, there are some perceived concerns about this legislative effort. First, there is the concern that once civil law is enacted, its rules will become fixed and very difficult to change or costly to change. This concern is what I call it fossilization issue. All the rules, once it was put in place, it became fossilized. Any errors or later revisions will take a long time, if not years or decades, to correct. Second, the quality of the civil code would be questionable if it was made in a rush due to a political agenda. The Chinese Civil Code project was supported by the ruling Communist Party. To gain this political support is a mixture of blessings, curses, right? So it's very decisive factor to determine success, but it also brings some side effects. Some of the current provisions have not been well thought out, therefore may not be satisfactory. For example, the first paragraph of Article 153 concerning contract validity, taking this provision on its face value, may seem logically circular and ambiguous without a clear-cut statutory definition of mandatory provisions of law or administrative regulation. So overall, the Chinese Civil Code is a milestone of Chinese legislative history towards a rule-based governance. This is because Chinese Civil Code is in line with legitimizing private interest and holding the public power on account. Despite of concerns expressed above, after conducting a cost-benefit analysis, the Chinese legislature decided to introduce the Chinese Civil Code at this point of time. Sorry, did you?
Yes, the slides are there. So please don't hesitate to tell me when I can move to the next.
All right. Yes, thank you. The notable rule changes and the second part from presentation. So in the Chinese Civil Code, for most part, the pre-existing contract law provisions has been remained without significant changes. The Chinese Civil Code includes some rules initially contained in the SPC judicial interpretations, such as doctrine of change of circumstances. Nonetheless, there are two notable, if not controversial, changes that deserves further discussion here. The first, there is no general part governing the law of obligations in the Chinese Civil Code, as contained in the Berkeley Gesetzbuch and Dutch Civil Code. It is worth noting that Kuomintang or ROC Republic of China Civil Code, which is still used in Taiwan through numerous amendments, have a separate part in the general rules governing law of obligations. However, the Chinese Civil Code, PRC1, dispense with such provisions. It is believed that the contract law 1999 has been a developed area of law with some 20 years of judicial practice. Thus, the contract law should not be overly modified. As a result, the third part of the contract book is termed as a quasi contract, referred explicitly to unjust enrichment and negotiatorium gestio, management of others' affairs without mandate or authority. So nonetheless, one cannot ignore the fact that the contract book contains 526 articles, which takes nearly 42% of the total 1,260 articles, thus forming the most sizable book of the Civil Code. Another controversy was recognizing the defaulting party's right to apply to the court for contract termination in cases where the breach is not willful and continuing performance would cause obvious unfairness to the defaulting party. This provision appears to solve the contract deadlock problem in China, which means the non-defaulting party should be in a position to terminate the contract, but they didn't. So, but this provision may cause many doctrinal and practical problems. It risks adversely affecting the contract balance, which has long been entrenched in the Chinese contract law framework. Consequently, in such circumstances, if the non-defaulting party refuses to terminate the contract, that would cause a high cost against the principle of good faith. Now we move to the property book. Next slide, please. The Civil Code has tinkered with the condominium rules contained in the Property Law 2007 on the collective decision-making procedures. Comparing the Civil Code with the property law, the voting procedure for owners to decide on the matters concerning common property has changed. The second part of the notable change in property book is the contractual land management right. So the contractual land management right over the farmland in rural areas has been defined as property right, usufruct right by the property law. The provisions in the Chinese Civil Code are still nebulous, unclear about the legal nature of the land management right, carved out of the right of contractual land management. So whether the land management right is a property right or contractual right seems to be unsettled. The Chinese Civil Code only provides that the land management right with a term of more than 5 years is created when the underlying contract of grant becomes effective. There is no strict need to get it registered in order to be effective. So it would be audacious or presumptuous to conclude that land management right is a property right, given its validity and registration rules. So it seems that Chinese lawmakers, through this compromised approach, produce unintentional ambiguity. In the tort law part, the next one, please. First, the Chinese Civil Code has established a self-contained risk rule, which governs situations where a person volunteers to participate in the recreational or sport activities that carries a specific risk. Second, it provides a self-help remedy rule. Under such circumstances, the victim may take reasonable measures such as distraining the property of tortfeasors to the extent necessary to protect the victim, but shall immediately require a state organ to take action. Third, it provides a specific liability rule in helping allocate the risks when a falling object causes injury out of high-rise building. The falling objects are a common phenomenon in the congested urban Chinese cities. I was interviewed by Wall Journal Street about this story, this provision shortly after the enactment of Chinese Civil Code. So oftentimes, the injured person cannot locate the tortfeasors in the circumstances. The Chinese Civil Code tackles this issue by providing where it is difficult to determine the tortfeasor, all the building occupiers will be held liable to compensate the victim, except those who can prove that they are not the tortfeasor. After paying compensation, the occupiers of the building will be reimbursed by the tortfeasor, who is found later. At the same time, the property management companies or other building managers shall take necessary safety precautions to prevent the injury from happening. If not, tort liability will incur for the failing performance of the duty of safety protection. So whether it's sensible to allocate the risk to all occupiers in the building is subject to debate. One possible impact of this, I call socializing liability rule, is to remind the apartment owners to get insured to avoid potential legal risks. the next part, please, on personality rights. Enacting a separate book on personality rights in the Chinese Civil Code is a unique arrangement that's strikingly different from the European approach. The following reasons may justify this unique arrangement. First, the PRC constitution only provides somewhat sketchy and symbolic provisions on protecting personality rights. Second, related to the above, even such sketchy constitution provisions cannot be directly applied when the Chinese court decide cases. Chinese judges cannot directly refer to constitution provisions as a legal basis to determine the final ruling. Therefore, there is a dire need to grant protection to personality rights by entrenching them in the private law sphere with the inclusion in the civil code. More to the point, as the growth of rights consciousness and the evolution of technology is never ending, a personality right book in the Chinese Civil Code may provide the opportunity to systematically address emerging claims in the personal spheres against technological risks through the high-level legislation. Nonetheless, it is too early to assess its impact shortly after its adoption. Much to be seen in the judicial practice on how readily the Chinese judges would like to grant the corresponding remedies. It remains interesting to observe whether the existing tort remedies to redress and prevent personality right violations and to assess the impact which digital technologies may bring to injuries of personality rights. The next part, that is kind of a snapshot of the notable rule changes in some selected books of the Chinese Civil Code. The next part is about what are the determining factors affecting the codification. So I only single out three part of the story to evaluate it. The first is the state commitment and political will is the most crucial factor to the success of the Civil Code. It would be a futile exercise by legal scholars in making civil code without requisite political will of the Chinese government or the ruling Chinese Communist Party. We learn from history, I learned from Professor Dewey that political push often plays a decisive role in ensuring a code success. It has been said the vital element in the success of the Napoleon Civil Code was Napoleon himself. Politicians delegate others with writing codes, but in the end, they who are not academic drafters have the final say. Xi Jinping, Secretary General of Chinese Communist Party, has himself instructed in writing to enact the Chinese Civil Code in June 2016 at a CCP Politburo Standing Committee meeting. This helps secure the political support of the Civil Code enactment. To trade in this political support, one can see numerous socialist value-laden provisions in the final product. For example, Article 1 and Article 185, and so on. Understandably, it is in the state's interest to respond to the social demands engineered by the growing middle class towards law-based governance. In the last 3 decades, there has been an expansive legislative approach to formalize certain contract rules and property rights. China has never conducted radical privatization in a rush. This experiential lawmaking approach have led to the development of market economy and a growing middle class. The second point I want to make is systemization and the coherence. Ideally, any code should structure all the topics for reasons of unity, coherence, and consistency. Perfect systemization and coherence are worth pursuing, but they may cause delay, thus risk losing the political will when eventually ready. Therefore, it is necessary to keep many expected to change topics out of the scope of the Civil Code. This way allows the legislator to enact since they are convinced that the faster a draft is ready, the more likely it becomes a code. Next, I want to talk about the status and the change. Sorry, that's still previous slide in the third part, status and the change. So the branches of civil law, particularly civil juridical acts, property law and family law, often seem to have a durable quality. Therefore, these laws are said to be static and context-specific. Also, it is said that in the academic world, plagiarism is a felony. In the history of civil codification, it is a virtue, right? So law drafters could just borrow the pre-existing codes in other experienced jurisdictions, and this phenomenon enjoys an elegant name, legal transplant. However, it cannot be presumed the narrative of the Chinese civil law is a history of status. As explained during the last 3 decades, there has been an explosion of legislation further supplemented by plethora of statutory amendments, judicial interpretations issued by SPC, fragmented department rules and local regulations. So many of the familiar features of general principle civil code, which mentioned by Marina in her presentation, have now been removed, sidelined, or transferred beyond recognition. For example, heavy-handed regulatory approval over the contract validity and the policies being the sources of law. To be specific, before the civil code, the Chinese court showed inconsistency over disputes concerning a contract pending regulatory approval. Under Chinese civil code, concerning contracts subject to approval as stipulated by law, the pending approval procedure will not affect the effectiveness of clause requiring the fulfillment of obligation to apply for approval. So if the party owning a duty to seek approval fails to fulfill such obligation, the other party may request it to be liable for non-compliance. Another notable change is seen in the source of civil law. So in the past, the national policy has been included as source of law, but under the new Chinese civil code, the national policy was scrapped off, replaced by civil customs. Well, this change is commendable because we all know that to include a policy in the source of law is against the spirit of rule of law, because policy may change over time without any legal certainty. But it's commendable to include a civil customs in. However, there are some issues out there still. A question exists about how to identify the applicable civil customs. There is a lack of guidance from the civil code itself. With time pressure to complete codification on time, the much needed service on local customs have not been conducted. Therefore, the Chinese courts are left with significant discretion to characterize and ascertain the widely recognized civil custom. So the final slide, the last slide I promise you, that is about what happens after the enactment of civil code. I think this point has been directly or indirectly highlighted by Professor Zhu and Marina in their presentations. So even if the wording and phrasing of the pre-existing legal institutions stay the same, they might be construed and applied differently in a new context. In other words, under Chinese law, the judiciary will play a far-reaching role in fleshing out the concrete legal task in case law. To be fair, the SPC, the highest court in China, Supreme People's Court, has taken the lead to issue the judicial interpretations as a source of law concerning the Chinese Civil Code, by saying it's a source of law because under Chinese legal system, the SPC judicial interpretations can be directly referred to by Chinese judges when they write their verdict or rulings. For example, the first batch of the SPC interpretation concerning the books of property, marriage and family, guarantee and security interest and succession have been already issued. But the contract and tort book judicial interpretations are still under discussions. I guess because this will be more significant, it affects the day-to-day life of Chinese citizens, more significant and important than other issues. That's why they are very cautious. It's a little bit time-consuming. So some people may fear that, well, due to the delay of issuing these SPC judicial interpretations concerning contract, that would affect, there will be some kind of legal vacuum, because when the civil code came into effect, the three judicial interpretations of SPC concerning the contract law have been repealed without being replaced, right? So people say, well, there could be some legal vacuum, but according to the SPC interpretation on the temporal effects of application of civil code, this won't be an issue because most of the cases the Chinese court face at the moment, vast majority of them, the facts of the case occurred prior to the 1st January 2021, when the civil code came into effect. So the old rules, old provisions are still applicable in this. But at a certain point in near future, there will be some demands to have these SPC interpretations concerning contract. So I hope that judicial interpretation will be introduced rather sooner than later. Sorry for being over time. I think I better stop here. Thank you very much.
Many thanks, Professor Chen, and for having helped us navigate throughout, through the Chinese Civil Code, and your points, I think, on the SPC judicial interpretations is definitely, I think, a point on which we are likely to come back in the Q&A session, just looking at the chat as it stands now. And just as a kind reminder to all our participants, if you have any questions to our speakers, please do not hesitate to raise them on the chat. And now it is time to move on to our third speaker, Professor Veneziano. The floor is yours. Thank you.
Thank you very much, Matthew, for the kind introduction. And the first thing I would like to say is that I am very honored to participate in this conference, and I would like to thank the organizers, and particularly my good friend and colleague Marina Timoteo, and also Matthew Burney for the invitation. Now, I understand I'm one of the few non-experts in Chinese law in this very prestigious conference. So while I will ask for your indulgence, if I will refer to the Chinese law and the Chinese Civil Code in a way which is not completely correct, or maybe even just from the point of view of terminology, my role is actually to offer a different perspective and to put the Chinese Civil Code in the wider context of the circulation of uniform law models and their influence of national legislators. And I will do this through the lenses of one of the most successful of such models, that is the Unidrop principles of the international commercial contract. I will now, here it is, I think this is the right one. Sorry, because, yes. Okay, so, the Unidrop principles were certainly hardly the only model, as we have already heard, but certainly among the relevant models for the new civil code. And this directly, but also indirectly. First of all, because the first edition of the principles had, in 1994, had already played a role in the drafting of the earlier Chinese law on contracts of 99. And this was already mentioned by Marina Timoteo and also by Professor Chen. A great part of the book 3 actually has remained unchanged, or almost unchanged. Maybe even more interestingly, the Unidrop principles played a role in the interpretation of that law, not so much directly through case law, though we have case law referring to them, but through secondary non-binding sources. In particular, for example, articles written by judges commenting decisions and using the principles black letter rules, sometimes the comments and the illustrations to support the conclusions of the decision. Or notes by judges to case law as guidance for courts. I understand that case comments of this type are circulated among courts, but they are non-binding, and they were again used as a support for the conclusions, for the decision of the court. Now, you see here the latest edition of the Unidrop principles in 2016. As many of you know, the Unidrop principles were first published in 94, and they are an international non-binding codification providing a set of uniform principles and rules accompanied by explanatory comments and illustrations that cover virtually all the most relevant topics of general contract and, for those legal systems that have this part, obligation law. And the other important point that facilitated their circulation is the fact that they were translated in all major languages, including Chinese. And you see here the Chinese translation of the 2016 edition. Now, the scope of application of the Unidrop principle is to international commercial contracts. But when we look at their influence on national legislators and sometimes also the practice of courts, we see that the influence has been wider as a sort of background law, it has been said, for general contract law. And in this respect, I'm showing this slide just to say that the Unidrop principles are a versatile instrument because they are soft law. So they are used as a tool, and they may be used and have been used in practice as a tool for party autonomy, for adjudicators, particularly arbitral tribunals, but also courts. And we have examples of involvement of arbitration and courts in China and also Chinese parties for these types of application of the Unidrop principles. But what I would like to focus on in the context of this conference is the Unidrop principles as model for national and international legislators. And also, if we have the time, as a means to support the interpretation of domestic law, which was a surprisingly important way that the Unidrop principles have been used all around the world by domestic courts, and was not even included in the first list of usages, possible purposes of the Unidrop principles, but it became a reality, and therefore it was included in the edition of 2004 of the Unidrop principles. So we come to the Unidrop principles as a model for national legislators. And the first question is why? Why were they seen as a suitable model? And one of the main reasons is that they are seen as a neutral, balanced, and practice-oriented set of rules of high technical quality. They were developed through a comparative law studies carried out over many decades and resting also on very big shoulders. So all the development of the international law of sales, first at Unidrough and then at Uncitral, achieving the CSG, the Vienna Convention. And they were prepared by a group of eminent experts sitting in their personal capacity, but representing all major legal systems in the world. And I think here we can speak of that linguistic, but also cultural translation and circulation of models during the development of the principles themselves. And they were finally adopted by an intergovernmental organization. Now, there are two main situations where the principles were considered to be an interesting and good model for legislators, among others. First of all, for transition economies, especially in the 90s, implementing market-oriented contract laws and therefore looking for different modern models with particular focus on party autonomy. For example, the Civil Code of the Russian Federation, particularly, I must say, the successive amendments to it, because that was before the first edition of the Unidrop principles, codes in Estonia, laws in Lithuania, and I think we can put also the Chinese contract law of 99 and partly the civil code, the part on contracts in this particular box. And then there are the traditional legal systems in need of modernization, also to render them more competitive in the international arena. This was a openly stated purpose for the French reform of contract law and the civil code in general in 2016, but it's true also for other reforms of commercial codes, for example, the one in Argentina. And I would also like to say that there was a different extent of the impact of the Unidrough principles on legislators. In some cases, we can see a literal transposition of provisions. Of course, then the interpretation is left to the courts, and there is always a hybridation of the concepts. But there is a literal transposition. It's particularly the case for Lithuania. But there are many cases where the principles were an inspiration for solutions adapted to the different style and goals of national law, drafting, and policy. And this is, I think, relevant for the Chinese civil code. And this is not a problem. I mean, the Unidrough principles as a tool are used insofar as they are useful. And there is always an element of harmonization, sort of spontaneous harmonizations in looking at uniform law models. And finally, and this is the point I would like to address more in details as far as some provisions of the civil code are concerned, there are different types of provisions in the Unidrough principles that have been used as model. There is a set of common core of rules for international commercial contracts, fostering convergence of legal systems. And those rules were actually already embodied in instruments such as the CSG, and they are part and parcel of domestic laws. If the country, as China did, adhere to the convention, to the treaty, and there are rules on the formation of the contract, rules on the remedies, particularly the damages, termination, and so on. But there are also in the Unidrough principles some innovative solutions which were considered to be particularly adapted to international contracts, but they are also seen as useful for the modernization of general contract law. And also in this case, we have seen the influence of the Unidrough principles. And now I will come to some examples of common core provisions. This is the part where I'm asking for your indulgent eye in looking at how I'm referring to the Chinese law. And so first, as we said, common core is particularly relevant in the rules on the formation of contract, at least some of them. And here we can see a clear influence of the CSG, which was already part of Chinese contract law for international sales, and of the Unidrough principles through the mediation of the 99 contract law. For example, the rules on offer and acceptance, modes of acceptance, revocation of offer, time of conclusion of the contract, and so on. But we also, and the typical example, I would say the modified acceptance, the acceptance that it contains modifications in respect to the offer, and it's considered to be a counter offer if it does not, if it modifies substantially the offer, or if the other party does not object promptly. Now, this rule is contained in CSG Article 19. It is also present in the Unidrough principles and in the contract law, Chinese contract law of 99. And we find it also in the civil code with, if I have seen, but I cannot read the Chinese, slight different terminology. But there was a specific influence of the Unidrough principles for some additional issues in the realm of formation of contract that are not directly addressed in CSG, nor in the contract law of 99. Some of them were actually. So, for example, different ways to conclude a contract, not only through the sequence of offer and acceptance, or the mention of standard terms and the interpretation of them, the contra proferentem rule, for example. Now, I have here other two examples of common core provisions. I will probably mention only one and then go to the last part, which is the innovative provisions, because I would like also to focus on them and would like to keep to the allotted time to allow for discussion. So termination of the contract and fundamental non-performance, this is again a sort of common core contained in CSG, and it has influenced court interpretation of domestic laws in many different jurisdictions, for example, Spain, but also the modernization of contract law in different countries. The Unidrop principles contain the same rule, with more details as to when non-performance can be considered fundamental. And we find a similar provision in the contract law of 99 and also in the civil code. And in this case, it's more similar to what the Unidrop principles provide than the general rule in the CSG. But there is an additional reference in the civil code to contracts concluded for an indefinite period of time. And this here, I can see at least an influence of the latest edition of the Unidrop principles in 2016, where long-term contracts are particularly addressed in the black letter rules, but especially in the comments and illustrations. In this respect, I would like to mention one of those interpretations, not formal interpretation, but a case selected for a case comment by judges of the Court of First Instance, referring to an article of the Unidrop principles, the article on the right to terminate the contract, and the Article 25 of the CSG, to support the ruling that the defendant's delay of performance constituted, in the circumstances of the case, a fundamental breach of the agreement. And so this is this interconnection of text of the law, a source, which is the CSG and the Unidrop principles, and also the interpretation by judges. And the use of the Unidrop principles to support a certain conclusion that is already present in the applicable domestic law. Now, the last point I would like to address is an example of an innovative solution. I think there was already mention of this in earlier presentations. So the treatment of supervening events that do not amount to the traditional force majeure, which are called in the Unidrop principles hardship. And in the Unidrop principles, indeed, we have a rather modern, very flexible regulation of hardship, which has been cited many times, especially now because of the emergence of contractual disruptions following the pandemics, which on the one hand gives importance to party autonomy, on the other hand tries to preserve the value of contracts, especially long-term contracts, and finally tries to allow for mechanisms for risk sharing. Now, the 99 Chinese Contract Act did not contain any provision regarding change of circumstances. We do have, at least with reference to the Unidrop principles, a confirmation of the Supreme People's Court of a decision terminating an agreement in case of substantial change of circumstances on the ground of the principles of good faith and the principle of fairness. I'm probably using terms that are not precise in this respect, but it's important to note that this use of general principles, good faith, solidarity, has been also a feature of other legal systems struggling with giving an answer to supervening events, like, for example, the French legal system before the reform, where a provision with similarity to the Unidrough principles rules have been then introduced. And there was also a comment by a judge of the Supreme People's Court making reference to the provisions on hardship of the Unidrough principles at the time, 2004. In 2009, I think that was already mentioned, there was an interpretation of the Supreme People's Court concerning and recognizing parties' right to request the intervention of a court to revise or to terminate the contract on the basis of the circumstances of the case. And now we come to the Civil Code, the Article 533. And in this respect, I would like to say that though, of course, it's a bit reminiscent of the Wegfall der Geschäftsgrundlage in German law, but it's much more similar to the UPIC provision than the earlier interpretation on two things. First, the definition of hardship itself as this supervening event fundamentally altering the balance of the contract, and then also on the consequences, because the renegotiation is mentioned, and then the courts or the arbitrators' revision or termination under the principle of good faith. So it's not the same, but there is a sort of a common way forward in many legal systems in this respect, including in this case the Civil Code. So I would like to conclude here and thanking again the organizer for the invitation, and I will listen and I will learn a lot from this conference. So thank you very much.
Many thanks indeed, Professor Veneziano, for your very interesting presentation. And now, without any further ado, I would like to open the floor for the questions and answers session. Please feel free to raise any questions you may have to our keynote speaker, Professor Duve, or indeed to the speakers of the first panel on the chat, which I will keep monitoring for this Q&A. We have 10 minutes left, which is good. There was one question at the end of Professor Chen's presentation, which was as follows. Does it mean that the enactment of the Chinese Civil Code signifies that courts will now have a greater power of interpretation like in common law jurisdiction? Professor Chen first, but maybe indeed if Marina or Anna want to react, or Professor Duve, indeed, please feel free to do so afterwards. Professor Lei. We can't hear you at the moment. Professor Chen, we can't hear you. You are not on mute, but there is an no. We can't hear you. No, we can't. Maybe if Marina or Anna, if you have anything to say about that, and then we come back to Professor Chen. Marina.
Okay.
Yeah.
Matthew. Okay, the role of the courts in common law jurisdiction is very precise. It is one of the typical traits of the common law system. So I think we cannot talk about an assimilation of the Chinese experience to that of common law. Okay, we know that the courts have a relevant role also in civil law countries, and in China, they started reflecting about this just because we have seen in my presentation the shift from the legislation theory to interpretation theory is just the outlining of the need to start thinking about this problem, how the role of the court contribute to the reshaping, to the shaping of the new civil law in China. We know that there is already a typical system that is that of guiding cases. in the Chinese law, which is one of the typicalities, specificities of the Chinese legal system as far as case law is concerned. So we have in China judicial interpretation and 司法解释, which are typical of the Chinese system. They have a link with the socialist model, but then China developed in her own way. We have this system of guiding cases, and then we also have the level of case law, of judge-made law, which has still to be fully explored. So we have these levels, which are Chinese, which are linked to a system where a mix of socialist law models and civil law models are in action. I think we cannot think about a common law influence, too many differences between the two systems.
Many thanks, Professor Timoteo. Maybe we can give it another try with Professor Chen to see if the sound is now working.
It is working now.
Excellent.
Okay,
Perfect.
excellent. Sorry for causing this trouble.
No problem.
Okay, so I just came back. I saw the message. I'm going to type in, but good to have this opportunity to answer straight away. And I think there are three, to answer this excellent question, there are three dimensions I need to articulate. The first is, I don't think, strictly speaking, the SPC will have a wider power like common law to interpret legislation such as Chinese Civil Code. This is because the court, judiciary in China generally has discretion to flesh out the concrete legal tests subject to the individual factual metrics of individual case anyway. That happened in the past, that's going to happen. Simply because Chinese Civil Code is a principle-based legislation. So inevitably, there are lots of details need to be fine-tuned, fleshed out. So the court SPC happens to play this role. The second dimension is the law itself is evolving, right? So I mentioned this in my presentation because I fear there's kind of fossilization issue. So once the civil code is provided, the rule is fixed and static. So, but unfortunately, the law is an evolving target, moving target, evolving concept. So in order to cater for the changing socioeconomic and cultural conditions, SPC need to catch up with this task. The third dimension is, as highlighted by Marina, this is kind of typical or unique arrangement for China. SPC judicial interpretations is functioning like condensed reasoning guidelines for all the levels Chinese court to follow when they decide cases. So this way, plus the guiding cases system, as you may hear of, is to ensure the similar outcome for the similar cases, right? Because it would be bizarre for such a unitary legal system, you have divergent legal outcome for the similar cases on facts. That will be very undermining the public confidence on the judiciary. So in order to deal with this, judicial interpretations and guiding cases will work together to ensure that the court will be take law very seriously. So that is a very short feedback to answer this question. Yeah, I hope it clarifies. Yeah.
Many thanks, Professor Chen. And if I may, we are privileged to have Professor Susan Finder from the Peking University with us this morning. So maybe, Susan, if you have anything to add on the role played by the Supreme People's Court, in the interpretation of the Civil Code, or in light of the question which was raised here, that would be very much welcome. Thank you.
Yeah, I'd like to follow up on what Chun-Lai had to say. That also, so I wrote, I think last month, the Supreme People's Court is working on a comprehensive judicial interpretation of the contract law part. But it's also a codification exercise. So they want to see how the civil code is, what are the frequently arising issues, and then bring those into the judicial interpretation, because the idea is also to instead of having a series of judicial interpretations, to have like one comprehensive one. So so last month I wrote about some of the details they're thinking of, but as I wrote, it seems to be early days. So my guess is we won't see a draft. Well, I don't know if we'll see a draft, and I doubt that it'll be finalized until 2022.
Thank you very much, Susan. And maybe
Yeah.
if you want to post a link to your article on the chat, I mean, that would be very much welcome.
Yeah, yeah. Actually, I did before at 5:19.
Excellent. Thank you. Thank you very much for that.
So I would also guess that the drafters of the judicial interpretation are looking at the Unidrop principles as well. But we'll see that when they publish their book, because the practice is to publish a book after a big judicial interpretation is released. So they'll probably say, oh, we looked at Unidrop, we looked at the German code, etc. They generally will specify some of the let's say foreign sources of law that they looked at.
Thank you very much, Susan, and many thanks for being with us. I do see on the chat that there is another question which is directed to Professor Veneziano. Could you please explain how the Unidroit principle of solidarity can be applied in the interpretation of the civil code in a couple of sample jurisdictions? Maybe that the sample of jurisdictions shall be limited in view of the time constraint, but this is indeed the question directed to you, Anna, please.
Thank you, Matthew. Actually, this allows me probably to correct a misapprehension on what I have said before. So the Unidrop principles do contain general clauses and general principles, such as the principle of good faith and fair dealing, and also the principle of cooperation, which is particularly important. They do not refer expressly to at least not in these terms, to the principle of solidarity, but we could see it as a part of the principle of cooperation among the parties. And then they have a number of more specific rules that concretize these general principles. And if I could just give one example taken from what I had already discussed, let's look at a situation of a supervening event, fundamentally altering the balance of performance and counter-performance of a contract. And let's look at a legal system where you don't have a specific rule for that. So the situation is either all or nothing. Pacta sunt servanda. This could be, for example, the earlier French law before interpretations and before also the new civil code. In that respect, the judges within the legal system have commenced to look at general principles such as, for example, solidarity in the case of the French civil code or civil system, the code legal system, or the principle of good faith in others, to substantiate a right of the party, the disadvantaged party, to request a renegotiation of the contract, which is what we also find in the Unidrough principles. And this is, for example, one of the ways the general principles of good faith or cooperation could be used in a specific legal system. We have seen that for example, the French civil code has now enacted a specific rule on that. So it's not the Unidrop principles as such that are applied, but they give more weight to an interpretation by the courts of that legal system, that you can use general principles to achieve a certain result. And then even you can concretize that in a specific rule. So we don't have much time, but I hope this example could be of help.
Many thanks indeed, Professor Veneziano. I think I cannot see any other questions on the chat. Just want to give maybe a last opportunity to anyone who might have a question. Professor Herbots, please. I would just ask you and the person will answer your question to be as brief as possible, just for the sake of sticking to the time. Thank you.
I could speak an hour about it, but I'll be very short. My question is this: in Article 1133 of the Chinese Civil Code, it is said that natural persons can establish a testamentary trust. That's the only mentioning of trust in the Chinese Civil Code. And my question is this. First, could you say, okay, this is a good evidence of what, for instance, Marina said, or what Chen Lei said about the continuation of the civil law tradition in China. Of course, everyone knows that trust is peculiar to the common law, and so this leaving out of the trust of the civil codes seems to show that, well, one stays to the civil law tradition. And my second question in this respect is, when you think that there is, since I think 2001, a separate law, a separate statute on a trusts for financial institutions, could you say that it is possible under the Chinese Civil Code to establish, to draft, to conclude a fiduciary trust-like contract, like you have in France, le contrat de fiducie? That's my question. Could be to Professor Chen, but also to Professor Di Matteo.
Many thanks, Professor Herbots. I'm allocating 1 minute each to Professor Timoteo and 1 minute for Professor Chen. So Marina, if you want to go first.
Again, as before, I think that we have to, how do you say, using a Chinese, a Confucian expression, we think to rectify the names. Trust is a specific situation which is perfectly framed within a system of property, of ownership law, which is a typical common law. And in civil law jurisdictions, even if we have introduced a plural concept of property, we are in a completely different situation. So we call fiducie, we call trust, we call fiducia in Italian, but the two situations are different because they frame into two different taxonomical words. So what we need to do is to make a word of linking rules with taxonomies.
Thank you very much, Marina. Lei?
Yeah, sure. This is an excellent question, Professor Herbert. Yeah, so good to see you. So yeah, I mean, the trust, as you rightly identified, there is a special statute of the trust law, PRC trust law in 2001, but that was meant to be a legal vehicle to attract foreign direct investment. So the trust concept has not been widely used in the civilian context, like the family or wealth planning and management, etc. But at this point of time, perhaps the Chinese legislature could consider whether we need to extend the use of the trust. The fiduciary duty was not, strictly speaking, used in this kind of like express trust or financial context, but fiduciary duty has been already recognized in the company law context, because there are a few articles in the PRC company law which adopted fiduciary duty with Chinese characteristics. Let me put it this way: they use the 勤勉义务, right? So they explicitly use the 勤勉义务, functional equivalent to fiduciary duty. But for family succession purpose, we haven't seen it. But it could be the case for future to realize that. Yes, good question. Thank you.
Thank you very much, Professor Chen, and also to all panelists, I think, for what was really, really a fascinating panel. Thank you very much to our three speakers. Many thanks again to our keynote speaker, Professor Duve. Many thanks to all participants for the excellent questions. And my suggestion now is that we go for a very short virtual tea and coffee break, and we will resume and start the second panel at 5 past the hour, fast past 11 Central European time, and indeed 5 past 10 GMT. So a 7-minute coffee break, and then we'll start again. Thank you very much. Professor Herbots, we are in your hands, so you can get started whenever you are ready.
Okay, fine. Thank you, Mathieu. So, ladies and gentlemen, my dear colleagues, I have the pleasure to ring the bell to start with the second panel. We will talk about some highlights on the Chinese Civil Code, namely the contract law. Professor Chen Lei already spoke about it, but we'll have now a new specialist. Secondly, the personal data protection, and thirdly, environmental law. And I will first, to start, we have not much time, I must be very strict on that. I will first give the floor to Dr. Mimi Zhou. Dr. Zhou is lecturing at the University of Reading. Prior to her post at Reading, she held the first post in Chinese law at the University of Oxford, in Oxford at St. Ugg's College. Her main areas of expertise are in the law and technology, dispute resolution, employment, commercial, and contract law. She wrote recently 3 books on contract law, my favorite subject, as Mathieu knows. She's also a qualified lawyer in Australia and England and Wales. Dear Dr. Zhou, you have the floor.
Thank you very much, Chair, and thank you very much, Mattia, Marina, and Angela for organizing this fantastic conference. And I'm very pleased to be sharing the floor with good friends of mine from across UK and Europe and China. So without further ado, I shall just share my screen, and hopefully you should be able to see my presentation today. I'll try and be quick. I have a 5-month-old who is asleep at the moment, so hopefully I can finish this presentation in the next 20 minutes while he naps. So, and so I apologize that I might not be able to stay around for questions, but I'll try and finish early so that you can ask some questions immediately after my presentation. So, so thank you very much indeed. So today I really want to just kind of reflect on the theme and draw on what I've been researching over the last few years that culminated in this book that I published last year, a few months after the promulgation of the Chinese Civil Code. I'm sure my publisher will be very happy for me to recommend this book to you. It is written for a wide audience, from researchers to practitioners and students. And it is a book that tries to make sense of the main provisions of Part 3 of the Chinese Civil Code, which focuses on contract law. So indeed, this is a book that you'll find that it's very readable, and I will be updating it probably towards next year because there's been new Supreme People's Court interpretations that have been issued, which actually a good friend of mine is in the audience. Susan, hello. I'm sure we'll have the chance to discuss some of these new interpretations during this conference. So the overview I want to give in terms of today's presentation is really just very straightforward. I won't delve into the depths of the contract provisions of the code. I want to give the code a historical contextualization by looking at development of Chinese contract law over the past 30 years, before looking at what is new, what is old. Suffice to say, there are most of the provisions in the new code actually are provisions from the 1999 contract law legislation. So I think in the area of contract law, there has been more continuity than change, but I shall highlight some of the areas of change very briefly in my presentation today. And finally, just as an illustration, I recently finished a paper with colleagues at Yunnan University on force majeure in the context of COVID. And I will just reflect a little bit on the sort of minor changes in this area with respect to the civil code. The background of the Chinese contract law needs to be elucidated if we are going to understand how we got to the civil code, because I think what's great about this conference and the papers in this conference is that it draws out the historical context of the code. I very much enjoyed the first plenary session this morning where different speakers really looked at the various influences on the code. So in terms of the contract provisions, what we have is the development of a contemporary regime of Chinese contract law in the 1980s that really track the development of the Chinese economy since the opening up in the era of Deng Xiaoping. And back in the 1980s, what we had was three major pieces of contract law legislation, which was the economic contract law, the foreign economic contract law, and the technology contract law. And those three pieces of legislation reflected the economic aims at that time, which was about state-oriented economic planning and market reform goals. So, for example, these legislations excluded natural persons. That was covered by the general provisions of the general principles of civil law in 1986, which was kind of arguably prior to the civil code, the kind of major piece of civil law legislation in China, which obviously has been now replaced by the civil code. So in terms of contract law, the three pieces of separate contract legislation was very much products of their time. They didn't even contain some basic rules regarding contract law, such as contract formation. The 1986 General Principles of Civil Law was as good as it could get, but there were only 10 provisions or so regarding contracts, and so it was not very comprehensive. So this is when sort of you fast forward almost 2 decades later, and you have the 1999 contract law. Some people refer to it as the Uniform Contract Law because it combined the three pieces of legislation from the 80s. And that was a reflection of, again, the times that China found itself in with respect to its economic development, its accession to the membership of the World Trade Organization at the end of the 90s. And so this was a major piece of legislation that the National People's Congress promulgated, which replaced the three previous legislation. It certainly brought much greater clarity than its predecessors. It has fairly comprehensive provisions governing not just general contracts, but also specific types of contracts. And we see essentially these provisions being carried over to the civil code. And this contract law 1999 pretty much draw on lots of different influences from international instruments, as well as influences from common law in terms of some of its principles and concepts. And at the core of contract law, the 1999 legislation was promoting party autonomy. This was a very important concept, again, reflecting the context in which this legislation was born, the shift to a more market-based economy with Chinese characteristics, and the need for less state intervention in economic planning, and certainly minimizes the role of the courts in terms of its intervention in contractual activities. So that was really a core principle of the 99 contract law. Now, we fast forward to today, last year, we have the Civil Code. The contract law provisions of the Civil Code can be found in Book 1 and Book 3. Book 1, as previous speakers have covered, general provisions that cover all sorts of judicial acts. And of course, that includes the act of entering into a contract. And then part 3 specifically, book 3 specifically, covers the general rules on contracts, as well as a new concept of new provisions regarding quasi contracts, and of course specific types of contracts. Now my fellow panelists will talk a bit about the green principle, which is an interesting concept, and that is one of the new principles of the Civil Code that also affects contract law. And it's interesting because in Article 509, it actually reflects this green principle. It requires parties to perform the contract with consideration of this green principle, so not to waste resources, for example, in the performance of the contract. We'll be very keen to hear our fellow panelists on how such provisions that reflect the green principle will be implemented in practice. There's been very small handful of changes to the substantive rules. And I should point out also that the 2 main judicial interpretations related to the 99 contract law have been repealed since the Civil Code has been issued. So some of the new provisions regarding contracts under the Civil Code include this 3rd subpart, which is on quasi contracts. And here we're talking about this concept of negotiarum gestio, which is sort of managing someone else's affairs without direct permission, and then unjust enrichment, which is also considered as a quasi contract. There are also new rules pertaining to contract formation. There's been some shift away from the offer and acceptance model towards a more broader consideration of contract formation. As Article 471 indicates, a contract may be concluded not only through offer and acceptance, but also through other methods. And there's also a new provision regarding contract formation in the context of e-commerce transactions, reflecting, of course, the digital era that we find ourselves in. There are new provisions in relation to validity of contract, and I just highlight 2 here. For example, it has essentially removed a provision in the in the contract law 99 regarding the validity of a contract that involves the unauthorized disposition of another person's property following subsequent rectification. Also, it makes available the remedy of rescission where fraud or duress is conducted by a third party, not necessarily by a party to the contract. Also, there has been an integration of 2 grounds of voidable contracts that were separate under the 99 legislation. What we find in the new Civil Code is the merging of 2 grounds of rescission of a contract based on taking advantage of another party's state of duress, and also the idea of the concept principle of evident unfairness. So those 2 concepts have been merged under 1 ground in the new Civil Code. Yes, another point I should mention is the new Civil Code introduces what basically does not allow parties to request modification of voidable contracts before the court, except in the very limited circumstances of the ground of change of circumstances. So other grounds of voidable contracts, the court can only terminate the contract. It doesn't allow the parties to request modification. So again, seeing that reduced grounds for court intervention, it follows the trend since the contract law 1999. So very, in the last 2 or 3 minutes I have, I just want to touch on the topic, which was a paper that will be published actually next month in the Journal of Contract Law that I wrote with Professor Wang Yi and Professor Wu Zhichen at Renmin University regarding force majeure and change of circumstances. our paper focused on the COVID context, but what I'll highlight today is just sort of the subtle change in the civil code compared to the 99 legislation on contract law. The definition of force majeure has not changed that much between the two legislation. But what's interesting to note is that change of circumstances was not mentioned in the Contract Law 1999. It was brought out by the Supreme People's Court judicial interpretation in 2009 that brought out this concept of change of circumstances. Now, under the Civil Code, force majeure, the provisions more or less reflect those of the 99 contract law. And I've just listed some of these provisions in relation to exemption from liability arising from non-performance, the ability for parties to terminate the contract if the purpose cannot be realized because of force majeure, the exemption of non-performance in light of the impact of force majeure, so it's not an automatic exemption. It could also be full or partial exemption of liability, and also the duty to notify the other party if force majeure was to be relied upon, and also exemption from liability from breach, and whether a party's delay triggers the basically non-exemption from liability from breach. So these provisions are more or less reflective of the 99 contract law. Now, what's interesting is that the civil code brings in, it's not just in contract law, it brings in many other aspects of the judicial interpretations related to the many pieces of legislation that incorporates. And in the context of force majeure, it brings in this Supreme People's Court's judicial interpretation on change of circumstances. However, it does not simply copy and paste this judicial interpretation. There is elements of change. If you look at this particular provision in the Supreme People's Court judicial interpretation, it basically says force majeure and commercial risks are outside the scope of change of circumstances. Okay, change of circumstances being a ground which a party can apply to the court and seek modification of the contract or termination. It's not the same as force majeure, but as we will see in the Civil Code, the provision of Article 533 actually recognizes the overlap between force majeure and change of circumstances. In this provision, change of circumstances only limits commercial risks in excluding commercial risks from the scope of change of circumstances. However, force majeure is not an exemption in this particular clause. So it means that a force majeure event can give rise to change of circumstances under the Civil Code, whereas before it was categorically excluded in the Supreme People's Court judicial interpretation. So that's an interesting a change that obviously was very relevant with respect to COVID-19 and the many situations of contractual non-performance that parties found themselves. So essentially, this is the sort of summary of this particular point. And once the paper is out, I will share it with the participants. It's coming out next month. And yeah, so this is the key takeaways. I just want to wrap up now and perhaps invite for some questions. There are elements of continuality and also elements of change in terms of the contract law provisions in the Civil Code. Of course, there's more judicial interpretations to come. So the devil's always in the detail. We will see how the Supreme People's Court will interpret some of the more general provisions of the contract law in the Civil Code. So watch this space. Thank you very much indeed.
You're on mute, Professor Herbert. You're on mute.
I was thanking you, Dr. Zoe, for your very clear overview of this great bulk of the Civil Code Party, Book 3 on contracts, with a special spotlight on that famous article on the changed circumstances. Thank you very much. Our second speaker is
Professor Herberts, if I may, as Dr. Zhou might have to leave us now, if there are any questions for Dr. Zhou, it might be good if the audience could raise them now, if it's fine with you, obviously.
Good. I didn't know that she had to leave. Yes, if there are questions. Mathieu, you read them on your, yeah.
Yes, and I do see that Professor Veneziano here has her hand up. So Anna, if you want to go first, and then I will go through the questions on the chat.
Thank you very much. I'm sorry, I didn't want to jump ahead of the questions on the chat, but I first wanted to really thank Mimi for an excellent presentation and for focusing on some of the issues that had an overlap with what I was also presenting. In particular, I skipped the part on the force majeure, and it's very interesting to see, as you showed, that these refinements of the provisions on force majeure, for example, to give prompt notice to the other party and the proof, the evidence to be given within a reasonable period of time, are completely in line with what we find in international instruments, and particularly the Unidrop principles. And the other element which is completely in line is the overlap of the two concepts of force majeure on the one hand and a hardship on the other hand, or change of circumstances. Not so much the overlap of the concepts, but of the practical situation. So a practical situation could actually, in certain circumstances, give rise to both, and therefore to have these different, very different sets of remedies. And the last thing I thought was very interesting was the refinement of the hardship, of the change of circumstances provision. And again, here, I thought it was extremely interesting that there was this reference to the renegotiation first and then the other remedies, which is something that you find in this developing convergence of legal systems and in uniform law. So thank you very much, Mimi, for your presentation.
Thank you very much, Anna. That's fantastic commentary from you.
Maybe I can go. There was an additional question on the chat, and maybe Mimi, if you want to react then to Anna's point and this particular question, and then we could.
Sure. I'm sorry that I didn't stop sharing my screen. I think it's okay now. So
no problem. I mean, there was another question here for you. Do we have any hint on how the green principle on implementation of contracts will be applied in practice?
Yeah, it's a great question, Hermes. I think I will leave this to my other panelists who will be talking about the green principle. It's obviously very topical, given that we are at a historical moment in terms of the climate summit, and very much China is trying to make itself the kind of leader, global leader in this arena. So I suspect that this will come from more policy side, how courts will try and implement this green principle. I wouldn't be surprised that they would be looking at this closely and trying to find cases perhaps in the coming months. I could be wrong, but I think certainly, as we know, the courts are keen to show to basically the general party state that they are also implementing party state policy. And so in this particular important policy issue, we might be seeing some guidance from the courts, some model cases perhaps, just to illustrate that this is a very important principle that is not just an abstract principle, because currently it is kind of an abstract principle in the code. We don't know how it will be really implemented on the ground. There are some provisions, like I highlighted, in performing contracts parties shall not waste resources. How is that going to be implemented and interpreted by the courts? I think, again, I suspect we have to wait and see. So sorry, I don't have a clear answer, but I think that given the policy importance of this area, environmental, building a green economy, green ecological civilization, I think the Supreme People's Court may be working in this area in terms of guidance, future guidance. And then the other question by Sulema, thank you for your question about why parties can't be terminated even if why contracts can't be terminated even if the parties wish to do so. I mean, I think it's an interesting question in the context of COVID, and I maybe drop me an email because we do talk about this in our paper in the context of COVID cases where there's been non-performance and parties have applied to the court to terminate their contracts. I think the court, when you look at the guidance from the courts in relation to COVID disputes, civil and commercial disputes, there's really a strong emphasis on trying to continue the contract performances. So force majeure is available as a remedy, but what we found actually was the policy direction of the courts was to try and get parties to renegotiate, to mediate. Mediation is also something that has been pushed by the courts, and to try and find an amicable settlement to the dispute, to perform it if it's possible, or to modify the contract in light of the circumstances.
Thank you, because we have to continue. Can you round up your...
Yes, so that's it. So,
oh yeah, I thought so,
yeah.
Yes. Thank you very much. Thank you. So now our second speaker, I don't think, Mathieu, there are other questions.
I think we are fine to proceed. Thank you.
So our second speaker is Dr. Wu Lan, who lectures at the Chinese University of Political Sciences and Law. I'm proud to say that I'm teaching a course there too, and I'm proud because that university is considered one of the best in China. Dr. Wu is not only teaching in Beijing, he's also teaching in the Winter School of the Project Law in China of the University of Bologna under the guidance of Professor Marina Timoteo. While privacy protection has been a hot topic in China for some time, the COVID-19 pandemic has created a sense of urgency around laws in this field. In August 2020, the Standing Committee of the National People's Congress passed an important personal information protection law. Now, to come back to the Code Civil, to the Civil Code, it was said already that its biggest structural innovation is to be found in a separate book 4 on personality rights. It includes a list of rights with a focus on privacy and data protection in order to tackle the legal challenges posed by the advancement of technology. Dr. Wu, you have the floor. We don't hear you.
Okay, it's okay now.
Yes, we hear you. Yes.
Okay. Thank you, Professor. First of all, I wanted to say I'm very glad to participate in this online meeting, and thanks to my professor Marina Timoteo for invitation. My topic today is personal information protection from Civil Code as Personal Information Protection Law, we call the PIPL. This is a very large topic. I will talk something highlight or something important in this part. The first one I wanted to talk is the legislative process of a person. Sorry, you can't see the PowerPoint? No.
Yes, we can see your.
It's clear? Okay.
Yeah.
The first part I wanted to talk is the legislative process of PIPL. In fact, I think the most important law enacted in China so far this year is this law, PIPL, which was passed in August and went into effect yesterday. So today's online meeting, I made this presentation. I think it can be considered timely. China's electronic economy has grown rapidly in the past decade, but the problem of personal information leakage is also more serious. The problem, first of all, the personal information leakage is in the sector of commercial. But with the breaking of COVID-19 in China, it's over-reliance on big data. Has also raised some questions about the use of personal information by the government public sector. In fact, Chinese legislators really took notice of the need to protect personal information can be back to around 2009, starting with the surge in number of telecom frauds. However, at this time, the legislations was mainly in the area of criminal law. It was not until 2012 that the Standing Committee of the NBC passed a document called Decisions on Strengthening the Protection of Online Information. This document is the first one in which the criteria of personal information has been clarified. At the same time, the principle of legal, proper, and necessary of processing personal information has also been proposed. The most important law before cyber security law 2016 is a departmental regulation called, this regulation is called the provisions on protecting the personal information of telecommunications and the internet users. Is made by the Ministry of Industry and Information Technology. This regulation is both technical and normative in nature. But the Cyber Security Law 2016 is the first national law that gives a clear definition of personal information in China. The personal information norms in the Civil Code 2020 are mainly scattered in 3 books. There are the first article is Article 111. It's a general provision in the General Book of Civil Code. And there are also rules in the 4th book called Personality Rights, and special rules on patients' personal information in the 7th book, Tort Liability. But the Article 111 seems to be a declaration of rights and interests. However, evidently not, I think it's not applicable. After the publication of JPCL in 2017, another issue discussed is about the nature of the rights to personal information. Some regards the right as one of the personality rights, and others think it's a property right. The book, the first book, Personality Rights, was formulated and to respond to this problem. The legislators listed personal information and the rights to privacy in the same chapter in this book, the personality rights. So now the right to personality is considered as kind of personality rights in the context of China. The time from 2021, the PRPL. The PRPL, the process, the legislative process of PRPL was long, and it took a long period of drafting and compromise before the first draft was published in December 2020 for it was published for comments, and then revised the second draft was published in April 2021, which was not adopted until the third review in August this year. The final PRPL, compared to the first draft, has changed a lot. As a law that specifically protects the rights of personal information covers, I think, almost entire remit of personal information in a comprehensive manner. On the handling of personal information on the problem of processing personal information is also include regulations on cross-border handling and the aggravating obligations of large platforms and the use of personal information by government. This is the short legislative process of on the personal information protection in China. The problem, the second part I want to talk about is the concept of personal information. The first one is information audit. I think our professors heard that I talk about always personal information, because personal information in Chinese 信息 is a standard nomenclature in official, public, and academic terms. Personal information in the context of China is different from personal data in Europe. Of course, the data is always translated in Chinese in 数据, and it's also different from personal privacy in the US. The privacy is always translated in Chinese into 隐私. This interesting distinction is not only a unique phenomenon existing in China, but also in Japan and South Korea, who share the same legal cultures of East Asia. Do the concept of information and data really have a significant difference, or they are just the same meanings, but only the different terms in different language systems? The scholars try to find out the answers by giving exact definitions to two words. In the Chinese language, the word information and the word data are different. Compared to the general data protection regulation, the GDPR of Europe, the concept of personal information in Chinese law seems to have the synonymous range as the concept of personal data in GDPR, both based on the identification of a specific nature person. But in the eyes of some Chinese scholars, it would be wrong to assume that the concept of personal information and personal data are completely synonymous in Chinese context. First, the Civil Code has explicitly distinguished data from the concept of personal information. The Art 111 in the first book of the general part of Civil Code use the word personal information. This article 111 is placed between the personality rights and the personal rights arising from marriage and family relations, while date is regulated by the Article 112.7 in Civil Code, together with the material assets, following the articles on civil rights. The different locations arrangement reflect the attitudes of Chinese lawmakers towards personal information and data. Besides the legislative ambitions of Chinese lawmakers to bring all forms of personal information within the scope of legal relation, another important consideration is the legislation of data property rights. Some European scholars also had criticized the use of personal data in GDPR, believing that the obstacles have been artificially created in common reach of data property rights. To promote the development of data economy and to protect the legitimate property interests of enterprises in data, suggesting a unified data property remedy to ensure the free flow of data may be another issue that Chinese scholars and lawmakers are considering. Another examples of different legislation is that the second draft of PIPL was published for comments on April 29, 2021, while on the same day, the second draft of data security law was also published. So there is some jurisdiction to divorce data, an electronic carrier. I think is the most important carrier of information from the concept of information. The second,
I'm sorry, but I see that the time is running. So.
Oh, sorry.
Yeah.
I wanted to
continue, but try to shorten a bit.
See. Okay. The next one is the right system. I think this part is important. The right system to personal information in this new law. The most rights to know, rights to decide, rights to review these rights, I think is very similar the provisions of GDPR, but there are some differences. For example, the right to eraser in the context of Chinese is not that one right to be forgotten established by the European Court of Justice. On this problem, the Chinese legislators and Supreme Court has the attitude more cautious for this problem. Now it's difficult to say that in Chinese the right to be forgotten is recognized. In this law, the personal information of minors and disease are also considered. The first, the personal information of minors in Chinese, principally, it can be processed. This is different from that article of GDPR, but the age of minors who can decide whose information is processed is lower. In China, is 14 years old, is lower than the 16 years old in Europe. But the information of the minor is compromised by the sensitive personal information, has a special rules in the processing personal information. Another problem I think the GDPR didn't mention is the personal information of the disease. This is also important. when natural persons died physically, but his or her information still existed in the website. So this article 49 is a special article for the personal information of deceased. The next one is the civil liabilities. This is important. Considering now in Chinese Civil Code, there are some articles about the civil liabilities when the internet rights was infringed by the others on the platforms this type. But considering that the general remedy rules in the Civil Code is difficult to effectively realize their functions. So in this PRPL, Chinese legislators made a new rule to respond to the civil torts on the personal information. In these rules, the problem is this article has adopted the unique doctrine of liability fiction without receiving a normal for no-fault liability, which seems that it's not flexible enough to deal with the complex personal information treatment. From the perspective of comparative law, multiple documents of liability fiction have become the trade of personality information protections legislations. There is another specific issue in the application of Chinese civil law, given that the personal information rights are located in the Book of Personality Rights in the Civil Code. The remedy rights to personality, or described by the term claim, is one foot of the civil liability system, while the other foot of this problem stands on the tort law. So the last one I wanted to talk is the gatekeeper in PRPL. In the second draft of PRPL, there is a very eye-catching new provisions, which is regarded as an important breakthrough in the personal information legislation. And and the provisions were reversed by the final versions of PRPL, which set specific duties for these huge basic internet platforms such as Google, Facebook, Apple, Alibaba, China, ByteDance, who are also the largest processors. The clause of PRPL has described this process as providing important international platform service involving a large number of users and complex business types compared to the general information processors, who may also be the business users of this platform. But the problem here is this platform, these large platforms has the right to manage to supervise the business users, the information processing rules of this business users. So it can be another problem is made because they have the power, they have the lawful and substantial power to large platforms in formulating rules. In the practice, maybe has another phenomenon of monopoly of these large gatekeepers.
Yes, please, can you conclude, because
okay. The last set say I wanted to say is, in fact, this law, this PRPL in China is a balancing experiment. Chinese want to reference the different legal models, the European, the American, and make a law or make a legal regime for personal information protection to balancing the different interests, the industry interests and the personal information protections. But this law now should be tested in the practice, and this part needs to be tested in practice over time, regardless it's perfection or a flaw in the series. Okay, Professor.
Thank you very much, Dr. Wu. Thank you very much. This is a completely new problematic, but it's extremely important in our days. And I thank you very much that you brought this up in this colloquium on the civil code. It's typical, it's very new. We would never have thought to have that in our Western codes. We don't have it in our Western codes. So it's very new, it's very interesting. Thank you so much. And our third speaker now is Professor Dr. Bien Yong Min. Can I see her?
Yeah, I'm here.
Yeah, there. Well, Professor Yong Min, welcome. You, after your PhD in international law in 2002, you became in 2007 professor at the Law School of the University of International Business and Economics, one of the elite universities, one of the Chinese elite universities, established in Beijing in 1951, I think, by the Ministry of Foreign Trade. Dr. Mimi Zhou cited already the eye catcher of the new Chinese Civil Code, Article 509, which emphasizes the protection of the environment when performing a contract. And environmental law, especially in international perspective, is precisely one of your research topics. We know China is a latecomer to climate seriousness, but now the President Xi Jinping is convinced that ecology is key to China's renaissance and is part of the social contract between the party and the people. The topic couldn't be missed today in our panel. Now the COP26 is held in Glasgow. And so you have now the floor, dear Professor Bayen.
Okay, thank you. And first, I would like to thank, could you see my slides? No?
Yes, we see. Yeah.
Okay. First, I would like to thank Professor Di Matteo for the nice invitation. And my presentation is on the Chinese Civil Code and the Green Principles. And mostly, I think for many countries, the protection of environment is provided by public law or administrative law, but I don't think the civil code is the best instrument for protection environment. But anyway, to integrate some green principles in our civil code is very helpful to connect our environmental law as part of the public law and the civil code as the private law, to my understand. We have, okay, sorry, let me see. Oh, sorry. Oh, sorry, I need to go to the first page. Okay. Okay, so first I want to clarify what green in the civil code means. It's unfortunately not covered climate change, which is a hot topic today. The green means in our civil code means resource saving, that is use less resources to do the same work or to improve resource efficiency. And the second means environmental conservation, to mind the environmental impact of civil activities. And the third means to restore ecosystem where environment is damaged and can be restored, and the infringer should restore it. There are 15 provisions related to green principles in the civil code. I categorize them into 3 categories. And the first group of principles actually, to my understanding, are most declarations. They have instrumental, instructional function, but for me, it's hard to enforce, as our previous speaker point out. For example, Article 9 provides civil subjects should, when engaging in civil activities, should be conducive to saving resources and protecting environment. And another provision, Article 286, provide the residents should conform to the requirements of resource saving and ecological protection. And to my understanding, you see that those are very blurred and abstract provisions, and it's very hard to enforce unless there are some other environmental law or other law that give more detailed obligation on individuals' obligation to protect environment. So those are, for my understanding, very only instructional. And for some, this kind of declarations also need support from other laws to make sense or to play a role. For example, Article 326 provide that the usufructuary right holder should abide by the law concerning protection and the regional development and utilization of resources in a rational way. And so it requires the other laws, for example, environmental protection law or environmental impact assessment law, to give detail about what specific obligation the right holder have to perform. Without the other provisions from the other environmental laws, and this kind of green principle, it's just I think advocacy to try to lead to some green development, but it's very hard to enforce. The second group is the principles need support of soft law or guidance. For example, Article 619 provide sellers obligation of packaging. It says the seller, when you sell something, you should have a package sufficient to protect the subject matter. And if there's no law on how you should package the goods, and you should have a package conducive to resource conservation and environmental friendly. But again, we need some industrial code of conduct or some soft law to tell the sellers what kind of package will be regarded as resource conservation or ecological protection. For example, in China, we have several important festivals, our Spring Festival, or we just have our Mid-Autumn Festival, and those festival food are packaged, always packaged in a very fancy way. Maybe just a very small cake, but with a big box, a lot of silk, plastic. Even you add one more tin of tea or wine as decoration for this very small festival food or gift or something. So there are a lot of critics on this luxury package, but they are not illegal package. So what is the proper package? We need some soft law and some guidelines and code of conduct, and to guide the sellers to give a proper package. And the third group of principles are the enforceable principles or enforceable provisions. Only this group of principles that the court can really enforce them. For example, Article 294 provides that the holder of real estate may not violate the provisions of the state, dispose of solid waste, or discharge harmful substance, such as air pollutant, etc., etc. And again, here, for example, the carbon dioxide has not yet be labeled or decided as air pollutants. Okay, we haven't have those kind of interpretation yet, so we cannot use this article to protect the climate. But if you emit sulfur dioxide or some other air pollutants, and you can rely on this article to ask the polluter to pay the compensation. And here you see that Article 1229 provide where environmental pollution caused damages to other person, the infringer should bear tort liability. But here the problem is, if there is a damage only happened to ecology, not to other person, and then this article 1229 may not apply. But then you can refer to other articles. You see the following Article 1234 provide if you damage the ecosystem, and the ecosystem can still be repaired, and then you have the liability to repair it. If you don't repair it, the government may have somebody repair the damage, and you will pay the cost. So this is something quite new, and actually this provision can be written into the civil code after a hot debate, and also very complicated calculation about how to decide the damage or ecosystem. For example, if a bird or a fish became extinguished after environment pollution, and how you calculate the loss of a fish as a nature species. For those questions, the provision of 1, 2, 3, 5 also gave the answer. According to this article, the ecological loss and expenses can be claimed in the following 4 dimensions, or the following losses are all covered by this ecological loss. For example, the loss of service function, the loss of permanent damage or environmental function, and the expense of clean up and restoration, investigation, appraisal, assessment fees, and all this, and you can claim. So I think, to my understanding, this is very broad and can be huge for the polluter, and we don't know, and we don't have any ecological fund as a backup for this compensation, just in case somebody accidentally or intentionally polluted a lake and cause enormous damage, because if that is drinking water, you may cause enormous damage, and then this infringer is very poor or have limited resource to pay the compensation, and then we don't know what will happen later, because the enforcement actually depend on or rely on the infringer's financial capacity to pay the compensation for the ecological loss. But anyway, we have this, and the good news is previously we have some factories intentionally discharge some dangerous waste to the public area, and since we don't have enough laws to for the government organ to claim compensation against the polluter, and some polluters just kind of escape their liability. I hope after this civil code enter into force, that the situation could be improved much more. The last, the civil code also, this is also quite new. We have a provision on punitive damage. This article 1232 provide that the court can sentence punitive damage to the infringer who intentionally polluted the environment or destroyed ecology. But we haven't got any case in this regard, and it remains to see, how the court will use this article, how severe, how big the punitive damage will be. But anyway, this is like some new sword, and so it can help us to protect the environment. Okay, this is not quite new, but this is also very important. Who will bear the burden of proof? Because many environment case, it's very difficult to justify the causation between the action and the effects. So the actor or the infringer shall bear the burden of proof if the actor wants to defend and to claim he does not bear liability, or his liability should be mitigated. And so since, you know, quite often that to present that kind of proof will cost a lot of even some financial resources, because you have to hire a third person or engage a third person to do the appraisal or assessment, or to present some other evidence. So this burden is also an important deterrent for the infringer to act nicely, not to pollute the environment.
3 minutes.
Okay, this is the real last page. So the significance of this green principle, I think it's echoed to the eco-civilization advocated by our chairman, Xi Jinping, and it also provides the legal basis for further legislation. As I said, we need a community code or industry code to guide the best practice. And it also provides rules for judicial body to enforce the punitive damage, compensation for ecological damage, etc. And the last, it will support the implementation of other environmental law. For example, in our environmental protection law, we have the environmental claim for public health, public interest. So we can support that, and we can also support the implementation of this environmental impact assessment. That's all. Thank you.
Thank you. Thank you very much, Professor Bian. Your topic was something also very new, not only in China. I know no other codes, civil codes in the world who have provisions like this. So this is something very new in the world of the civil codes. I think also of the punitive damages in civil law. In Western law, as you know, we don't have that. We don't have punitive damages. That's punitive, it's for the criminal courts, but we don't have it, and we should. There are tendencies now coming up also to have them in our codes. It's a good evolution, I think, but of course it's discutable. I just say it, but I have certainly colleagues who say, what is he saying? No, thank you very much for your presentation. And now we arrive, well, yes, we arrive already at the conclusions.
We have time for the Q&A, I think, Professor Herberts. We still have time, right? I have several questions from the chat.
Well, I saw it's nearly 20 past 12. Do we have time for
I think we definitely have until half past 12, right? I mean, because Hermes is 15 minutes, so I think it's fine, right?
Excellent. So you are invited to put your questions in chat box which will be analyzed by Mathieu, notre éminence grise.
Thank you, Professor Herberts. I mean, already several questions actually for our third speaker in particular on the green principle. I mean, I have two questions for you here with respect to green practices. Would the International Organization for Standardization principles on relating to packaging and the environment be able to serve as guideline for courts in interpreting Article 619 of the Civil Code? So this is one. Then there was indeed another question, the pollution and do the pollution and environmental harm present in Article 1229 also implied a violation of a state regulation, as in Articles 1234 and 1235. Maybe we can get started with these two questions, if it's fine with you.
Okay, so I can start. I think, of course, the guidelines from international organization can be referred to in the implementation of the green principles of our civil code. And recently, because those are generally technical nature, I mean, they don't conclude any psychological conscious no political items in those packaging guidelines. So in that sense, the court will be it will be easy for the court to refer to these technical guidelines. For some other guidelines from the international NGO, they may contain certain, political or social thoughts or items in it, and then the court may very hesitate to refer to those guidelines. I didn't quite get the point of the second question. Is the pollutant? Sorry,
Mathieu.
The second question.
Let me try to go back to it. Sorry, I was already preparing the next questions. So the next question was the pollution and environmental harm reference made in Article 1229 also imply, do they also imply a violation of any state regulation, as it is the case in Articles 1234 and 1235?
Yeah, they also applied to those activities or violate the state's regulation and laws. Actually, I think the state will have, as I said, some kind of public law to support the implementation of the green principles of this civil code. Thank you.
Thank you.
Other questions?
Yes, there are other questions on the PIPL. First of all, a question from Hermes. Let me go back to it. The PIPL has at the moment no implementing regulations. A draft regulation was published for comments on the 29th of October, but not promulgated yet. This leaves significant doubts on how the PIPL will be implemented in practice, as many of its provisions are relatively vague, in particular with regard to the export of personal data. And the question to you, Dr. Wu, is do you know what the government plans are in this respect? I guess we'll all be interested to know about this. And maybe indeed a second question on the PIPL, which comes from the Eminence Grise in the room, myself. The question here is, to what extent do you think that the adoption of the PIPL by the PRC, could potentially lead to an adequacy decision being made by the European Commission in light of the EU GDPR? Or to put it in different words, what are, in your views, the scope and still challenges for the PRC to be recognized as a jurisdiction providing an adequate level of data protection in light of the GDPR?
Okay. Thank you for the question. I saw the I saw a question here in the chart function. First of all, I wanted to see the legal provisions are very vague. This problem is not the problem of PRPL. The civil code, the Chinese law, all I think all have these problems because the provisions vague can give more powers to judge in practice, and the problem of this type, this characteristics of legislation is that the laws and the articles of the laws cannot be applied correctly in practice. Not only the problem of PRPL, but also the in the civil code, in other laws of China. At present, you said these regulations are being developed, in process. It's right, and it's published for comments. For public comments, but there are many controversies in these problems because in accordance with the legislative, the Chinese lawmakers now, the basic attitudes about the cross-border of personal information is under the serious management and supervisions for the enterprises want to development in out of China, in other countries, if they should provide the personal information of their customers to other countries, foreign companies, it will be invested, and it will be supervised seriously in future. This is sure, but because this department, this regulations now is in process, it also has many characters and controversies on this. So now for us, maybe we should look the decisions of the government and how go forward these regulations. I'm sorry, I didn't hear the second problem, the second question.
So the second question was, I mean, relates to, the PIPL and its relationship with the European GDPR. I mean, as you may know, I mean, in light of the GDPR, I mean, the European Commission can adopt so-called adequacy decisions, which means that in practice, the European Commission can recognize that a non-EU country does provide, I quote, an adequate level of protection of personal information and personal data. The European Union has done that with Japan. It is now in the process of doing that with Korea. And my question was simply to what are, in your view, the scope, but also the challenges indeed for the PRC to be also recognized as a jurisdiction providing an adequate level of protection, an adequate level of data protection from that perspective?
Okay. Yes, in the process of PRPL, we made a lot of reference to GDPR. We can see that right systems of personal data on personal data has a lot of influence, have a lot of influence on the legislation of PRPR. I think most rights to personal information, the articles about these rights to personal information are very similar to GDPR. In PRPL, one part I didn't mention in my presentation is that the regulations on the provisions on the cross-border of information, and jurisdictions in outer sea, in foreign sea. This part is also important in the development and application of PRPR. In fact, the development and the economic business in China and in Europe is different. I think this is why the Chinese legislators thought about which legislative model the European, the US, we should choose in our personal information protection law. But because this law entered into effective yesterday, so there are some things we can't say now. It should be tested in practice. It has a lot of problem. This is a fact, but the news is new things or the advantage is that we finally have a law about the personal information protection. Maybe this is a declaration of the rights in the legal systems, but we need to test in the practice in future.
Thank you very much, Dr. Wu. Was that enough for your question, Mathieu? I imagine you were the
yeah, definitely. And just to say that we are done with the questions on the chat, but I just would like to point the audience to a very interesting discussion between Professor Veneziano and Professor Chen on indeed the categorization of the change of circumstances doctrine and the force majeure in the context of the civil code. So I just would like to point to this interesting discussion for those who are interested.
Very interesting indeed, yes. No other questions?
No.
I mean, not from you, but from the audience. No. Good. Then it's time to arrive already. It's time to arrive at the conclusions. And to draw the conclusions of this colloquium, we are happy to have among us an important solicitor, Hermes Pazzalini, the head of the China desk of the expensive Italian law firm, the Advanced NCTM law firm, with offices in Milano, Rome, London, Brussels, and Shanghai. Indeed, before becoming partner here in that firm, he was a senior associate with Allen and Overy in Shanghai. And he has spent decades working in China and speaks fluent Mandarin. He deals mainly with commercial law and arbitration, with a particular focus on the relations between Italy and China. Recently, he wrote already a book on the new civil code. Gentile signore, lei ha la parola.
Grazie molte. Thank you very much. Thank you very much, Professor Herbert, for the nice words, and thank very much to all the speakers. For me, as a practical lawyer, of course, I read the code many times and I used it a number of times in practical situations. However, this conference for me was extremely interesting, extremely useful. On one side, for the interesting new topics, topics that were new for me, such as the comparison with Unidrough principles by Professor Veneziani, or the new issues, the changes that the code introduced that Mimi Jo pointed out. And okay, from my point of view of somebody who's following the development of Chinese law in practice, to me, the civil code, well, first of all, you can see that the Chinese government is using legislation to bring China through a particular journey, through a particular path, okay? In my personal view, and my Chinese colleagues may disagree with me, but there's a very strong personal view China is not simply trying to perfect its legal system up to an optimum, but is trying to use its legal system to move China from point A to point B to point C through a particular journey. And here we are at the step in the journey that Xi Jinping calls 小康社会, okay, a moderately prosperous society in which perhaps Chinese people are asked to not to be so competitive, not to work so much, to get a bit more relaxed, to have more rights, to have more holidays, to have more children, to study a bit less, to have more welfare. And in this situation, the civil code has been introduced. Civil code, which is a German code with English characteristics and with Chinese characteristics. Now, what are the Chinese characteristics that I see in my everyday life of a practical lawyer? The biggest of the Chinese characteristics, quite apart from Confucian elements in the inheritance law, whatnot, is the relevance of the public element in private law. And that is exactly what Professor Timoteo said, though referring to a paper that I think was in the 80s. Chinese law is the big law that regulates the relationship between the state and people, and not only the relationship between citizens. Okay, this is no longer true, right? Because since then, we've got the 1999 contract law, we've got a number of things, and private law now is private law. But it is, when Professor Duvet talks about normative knowledge, okay, what resounds into me is that we need to know the law that is not written. Only then we can understand what the difference is between the Chinese civil law and the German civil law or Italian civil law, right? Now, again, Professor Timoteo mentioned Jiang Ping, who said, we crossed the river by feeding stones. What does feeding stones mean in practice? It means that in practice, certain rules are implemented as a test before there is any law, okay? Or it means in practice that certain policies are implemented without a written instrument. Professor Chen has very rightly pointed out that national policy is no longer a source of private law. True, absolutely true. But a few weeks ago, I got a telephone call from the local, what do I call it, the neighborhood committee, the Juwei, the smallest unit of administrative power. And they said, we are interested to know whether you would want a lift, a new lift installed in your apartment building. Now, if this happened in Italy, I would say, this is none of your business. This is a private matter. We will discuss it among owners. Okay? Yeah, this is a public matter, but it's also a public matter because there are several elderly residents, and if they leave it to owners, owners will never agree, and so they kind of give it a push. Yeah, and the opinion of the local resident committee will be relevant. We not be definitive, because if the majority of the owners say no, there's going to be no, but it's somewhere there. And the resident committee has also a number of powers in relation to the appointment of guardians to for orphans without immediate relatives, also in the civil code. And it also contains a number of things on privacy and on the green principle, on environment protection, that are, as Professor Bien and Professor Wu rightly pointed out, probably more the domain of public law, just as the export of data. The export of data is a super big issue. Is it private law? No, it's public law. That's what that's what I find particularly relevant. That's what I think should be studied further. Also because it doesn't simply relate to the communist idea that the state has to bring the people from capitalism to socialism and then finally to a happy and perfect society that is communist. But it also relates, in my personal opinion, and this concerns also an article I wrote some time ago, though in Italian, the fact that there is a general principle of obedience in China, an unwritten principle whereby obeying the authority is a value, far more than it is in Europe. And I give you another example. There is, again, when you go to register a company, the first thing you need to ask yourself is, does the local register have a standard articles of association? Because if it does, you need to use that. It's not written anywhere, but in many situations, the local register will tell you, you need to use our standard. You cannot write your own articles, irrespectively of how lawful it is. And if you ask a Chinese lawyer, is this lawful? Can I challenge it? They say, no, they didn't really have the right, but just go along, okay? So these are the kind of double realities this new civil code we have to face. And with that, I've concluded.
Thank you very much, Hermes, and for this summary. I mean, it's obviously very difficult to wrap up. I mean, a very comprehensive analysis which has been provided by all our speakers. But many thanks indeed for sharing your views. It is now, I think, time to conclude this half-a-day conference on the new civil code. I would like really to thank all the speakers, also on behalf of Professor Marina Timoteo, for these excellent presentations. Honestly, I mean, I will definitely use this recording, I think, this event recording for my introduction to Chinese law in the second term, because it was extremely comprehensive, detailed, thought-provoking, and for someone in the room who is not, I mean, a private law specialist. I mean, I come more from the kind of international law perspective. I mean, I must say that I really, really learned a lot. So really thank you very much to all the speakers. Many thanks to all the participants for their questions. If I may encourage all of you to keep following the activities that we organize in the context of the Jean Monnet Network on EU-China legal and judicial cooperation, which brings, I mean, a number of European universities, including obviously Queen Mary University of London and the University of Bologna, but also 3 Chinese partner institutions. So please keep following our activities in the months to come. And I can not conclude this conference without saying that it has been, as always, a great privilege and honor to collaborate with Marina in the context of the organization of this conference. And a big thank you to the whole team at the University of Bologna for the organization of such a perfect online conference. Many thanks to all of you, and wish you all a very good afternoon or evening, depending on where you are in the world. Thank you very much.
Yeah.
Thank you, Mathieu.
Thank you very much.
Bye-bye.
Thank you, Marina.
Bye-bye.
Bye. Bye-bye. Thank you.
Thank you.
Hi, everybody.
Bye.
Bye-bye.
Ciao.
Thank you.